Yes, madam.
Item number 21. Kindly the matter vacation.
Your for? You be there. Let the matter be called up.
See, he,
Be. Oh. Have you informed the other side?
yes, I already understood.
What is there in this matter? Okay. Prayer is made on behalf of Mr. M.R. Adhikari for the respondent, government in the matter on the ground that he is in bereavement. Prayer is not objected to by the learner. Accordingly, raised after 2 weeks. After vacation.
May please, Your Lordship. Lordship, in item number 5, my lord, by last order, you are directed to produce the appropriate copy of record, my lord. That is the translated copy, my lord. All are in Hindi, my lord.
Rejected.
My lord, already sent to the department, my lord. They will produce the, they will serve the translated copy, my lord.
What is there? You attempted suicide from your officers, the man who is there.
He's just, I am for petitioner, my lord. He's just.
Thank you, Mr.
Yes, Mr. Sheikh. This is an allegation of suicide. In the full inquiry, in the appeal, in the revision, you have never taken the plea that you are taking now in the writ petition. How can we give a credence to that?
If it was taken anyway, my lord, I am
Not.
only thing, but that especially documents are with them that will be returned, my lord.
We'll do that. Let the matter be called up. We will do that. Do that. Why are you keeping his educational documents? Give it back.
Lordship, back to mention item number 9. Due to some personal difficulties of my senior IH Shaikia, matter may be taken after vacation.
Why?
There are some personal difficulties.
Who?
IH Shaikia, sir.
Prayer is made on behalf of Mr. for an adjournment in the on the ground. Prayer is not objected to by the learned counsel. Matter stands. History to list the
Please. May I please, Your Lordship. Lordship, this is regarding that rank and pay of the this Assam Rifle personnel with that of the
You
BSF.
are trying to now draw the analogy from the radio mechanics.
No, Lordship. First, I would like to place the recruitment rules. The BSF recruitment rules, I could collect a copy
We
where,
have not filed a reply.
no, Lordship, that reply was not filed because I lost contact with the clients.
They are not interested.
No, actually, he has retired and he was pursuing the matter. After
Okay.
COVID, probably he might have lost my number.
Where is the recruitment rules?
Lordship, that I have collected, the old document.
And you were supposed to submit a written argument with bringing all these things on record. If you don't file an affidavit, this court had required you to file a written argument,
Yes, Lordship.
bringing this comparison on record. Order dated
Yes, Lordship, that is, there is an order.
5/2. Why have you not done that also?
Lordship, because I have collected this recruitment rule day before yesterday.
Okay, what is the difference?
That BSF rule says that there should be 40% post by way of absorption in the head constable as fitter.
No, we are not on that. The entry cadre in BSF requires the qualification of that post, straight qualification to be acquired, right? In Assam Rifles, only a matriculation is required.
No,
Once you enter, they sent you for the training.
no, before remasteration, he will have to go for a training at EME centers.
You are recruited as a rifleman or someone, then you go for remasteration. When you apply for remasteration, you are sent for that training.
Yes, Lordship.
Once you come back, you are then as that, what do you call that, electrician or something. Is that
There's a proficiency EFS fitter.
a fitter?
Yes, Lord.
Now, you are only in the fitter cadre. Now, you have two pleas in your writ petition. One, that I have completed the courses. So with the completion of the courses, my progression in service also has to occasion.
That is subsequent.
One. Subsequent. Second is, once I have become a fitter, you will have to now give me parity with BSF,
Yes, Lordship.
right? Their plea is that this cannot be done because the work is different. Two, the qualifications for recruitment is also different.
Lordship, the work is not different. They are saying that the qualification is different. The qualification given in the EME is equivalent to ITI, even it is higher than it. There is a judgment of the Allahabad High Court in different context where this issue was there. Whether the trade proficiency certificate issued by these EME centers.
We agree to that. We agree to that. But when you get in, you are not getting in with that qualification. You are getting in with a lower qualification. That is settled by the Supreme Court, that the qualification, difference in qualification of recruitment would be a ground for denying parity.
Lordship, here the qualification, once I acquired qualification, then only remasteration is done.
And then
Not
remasteration, you
before
must be
that.
given Havildar directly.
Because in the after this obtaining these sequent qualifications in BSF, they are given the rank of Havildar. Because by way of absorption, they are also that they are from the constables. If they come, the 40% posts are from the constables. And
Yes,
these
Mr.
constables,
Gogoi, what do you say on that? That's the only issue.
This is the only issue. Basic issue is the educational qualification is totally different. Even lordship, the mechanic in the Assam Rifles.
No, we don't want to go to radio mechanic
Yes,
because
you
that is already settled. What about the fitters?
Education is totally different.
Then the radio mechanics also, the educational qualification was different.
Fine.
But this court, Supreme Court had directed them to be given that benefit. You have given them that. Why the benefit was not given to the others?
Lordship, across that part, lordship, is because lordship, the qualification and job profile is totally different. That's why
Top profile not very clearly mentioned in your affidavit.
lordship, otherwise also very high. When lordship, the electrical fitter, lordship, when lordship, this was in the Home Ministry notification. Assam
The
Rifles-
government of India had excluded the
Eh,
Assam Rifles
Assam
from that,
Rifles, lordship,
the NSG.
energy loss.
Have you challenged the rules, recruitment rules?
no. Recruitment rules we have not
See,
challenged.
if you don't challenge the recruitment rules, the recruitment rule says that you have a vacancy, then you go up. Without making a challenge to that, can we entertain you?
No, because the here, the entry in the grade, this has happened because of the different nomenclatures used in Assam Rifles as compared to the
Have
other
you
CPs.
challenged that Government of India notification, which says that one rank, one pay in respect of CAPFs, Central Armed Police Force, excludes NSG and
Lordship, then there is another, already that was written to them.
you have not challenged that. have you?
No, because that issue was taken up in other petitions and that was considered. And the benefits was given to all other ranks because they are also having the similar.
You bring in on record your written argument. You're
Yes.
dealing with the contentions in the affidavit. Let him bring,
Lordship, I know-
parity of pay.
I know.
Heard the learned counsel for the parties at some length. However, hearing remains inconclusive. Mr. S.N. Tamul submits that he would bring on record a written, he would file a written argument therein highlighting the parity with regard to the qualifications as well as the work, the nature of duties discharged by the petitioner and similarly placed persons in other Central Armed Police Forces, CAPFS. Registry to list this matter again on 28 Pari, 28 for 2026 for further hearing
Can it be in the month of May? Because I will have to collect the complete
on
recruitment. report.
5/5/5/2025. You give it back. Let not prejudice this.
Much obliged.
Lordship. Lordship.
Social Welfare Department. Ms. Bachchaji, who is appearing for the social welfare? You shall appear. Now, tell me one thing. You have a doubt with regard to her. It's a case of impersonation projected by you. Why don't you draw up a proceeding and finish it off? If she is not, because it's not very clear whether it is she or somebody else. Yes, how do you distinguish this?
Now,
FR.
FR, yes. So that is my instruction as of today, that the final report was submitted in 31st December 2023. So it is good that
This court attempted.
this court has also attempted through registry. So there one thing has come out, that the person who joined in Durlabh Chera, the earlier ICDS project, is the same person who joined in.
No, it is not very clear.
No, that
No,
much has
those
come.
persons who were there in Durlabh Chera had come in afterwards.
They had come afterwards, yes.
The deceased report throws some light. The
Yes.
inquiry report with the
With the
director,
FR, with the
that throws some light that there is an impersonation. Madam, he is working. She is working.
no, she.
This will have to be heard in detail. The only way out now for you is drop a proceeding if she is there and finish it off. Either way. And when did you get divorced?
That exactly, Lordship.
What is the instrument by which you got divorced?
Lordship, I'm not very sure about that. Because of course, sex.
You have used the word ex-husband in
Yes,
your
yes,
affidavit.
yes. Yes.
And the ex-husband also happens to be the husband of the other person also. So we want to know.
Actually, the ex-husband, there is a personal tragedy here. That the ex-husband is the husband of my sister now. That thing is also, of course, not a matter of record, but that thing is also there because it has went to that. So that's why I'm saying this.
We got it. But how did you divorce? You're governed by the Muslim law.
Yes.
So there has to be a registration of the divorce with the Kaji.
Yeah.
Because this was happened when the 1935 Act was enforced.
Sharia Act.
Get me that thing. Then we will see. If you don't have that, that means there is some. Because you have used the term ex-husband in your affidavit.
Yes.
How did he become ex? It is not late, it is ex.
Yes. And that person is still there actually because of an affair with my sister.
Fine, that is your personal problem.
Yes.
But I want to know, when did you get married and when did the divorce occasion?
That, Lordship, I'll have to get.
Ms. M. Bachchaji, Learned Counsel appearing for the respondent submits that she would. You just have this instruction, whether she is working and or whether you are contemplating any proceeding. Or I'll not put that because your stand is that she is not the man. So why proceeding is required? The Learned Counsel for the petitioner, after attempting to argue the matter at some length, submits that on a query made by this court, submits that he would, on the next date of listing, apprise this court the manner in which the petitioner had got divorced from her husband, if Muhammad Hibzur Rahman. The said information be placed before this court the next date of listing. You just take our information, I'm not putting it, just take our information. Registered to list this matter again on 30/4/2026, on which date the said information be placed on record by the learned. You can take this back.
Lordship,
Otherwise, Mr. Counsel, this disputed question we are not going into.
Lordship, the police has investigated into the disputed question of fact.
FR is nothing. They might have said that we could not get any material. That will not give you a status. There is a very big doubt here. And in between, your name also got changed in an order.
No,
We'll see. You get these details. Any difficulty in placing that detail?
No, the personal thing, the marriage thing. No, I'll please.
Both marriage
Yes, and the divorce.
and the divorce.
Marriage and the divorce.
Marriage certificate and the divorce certificate.
Worship, whether certificate is there or not, I'm not.
You have to have a certificate. Without a certificate, how can a Muslim marriage be held to be valid?
Or I'll take it.
35 Act, you will have to have. Yes. Division bench still
Yes.
registry to list this matter again after 6 weeks. In the on the next date of listing, the counsel for the parties to apprise this court as to whether the writ appeal, being writ appeal number 72 of 2023, has been disposed of by the division bench of. Yes, what do you want? The education certificates.
Yes, I in the prayer also I mentioned.
You don't want to challenge this.
It's a losing game.
We'll accept his prayer. Mr. Mukhtar, S. Mukhtar, learned counsel for the petition. Heard Mr. S. Mukhtar, learned counsel. Also heard Mr. S. Z. Rahman, learned counsel. Learned counsel appearing for the respondents on behalf of Ms. Y. Doloi, learned CGC. The petitioner in the present writ petition has presented a challenge to order dated 10/6.
14/117, past 1 minute.
No, that is the memorandum of charge. 13. Annexure 13 is page.
And except 13, please.
Sorry. Where is the disciplinary authorities order?
Yes, there is 10101 mile, 141. 141 mile. Relevant page is 147. I've been removed, my lord.
Removal order.
Yes, 147 is the relevant part.
The order is 14/1/2017,
Yes.
by which the petitioner was imposed with a penalty of removal from service after a departmental proceeding was so instituted against him. The petitioner has also assailed the orders passed by the appellate authority and the passed by the appellate authority, rejecting the appeal of the
Yes, ma'am.
petitioner. The order dated so and so
10
2017, passed by the appellate authority, rejecting the appeal preferred by the petitioner, order of penalty as. So, Mr. S. Mukhtar, after having attempted to argue the matter at some comma, and during the deliberations, it having come on record that there was no irregularity committed in conduct of the proceedings against the petitioner, and that he was given a due opportunity, but no material having also been seen to have been adduced before the inquiry officer with regard to the pleas thereafter taken by the petitioner, Mr. Mukhtar has submitted that the order of penalty may not call for an interference with by this court. However, he submits that the petitioner, that the original educational documents pertaining of the petition,
Marksheets and certificates.
including the original mark sheets of his HSLC,
Marksheets and certificates.
mark sheets and certificates of the
HSLC
HSLC
and
and
SSLC.
HSLC examination, which were produced before the respondent
At
authorities
the time of appointment, my lord.
Huh?
At the time of joining, my
at
lord.
the time of his initial recruitment
Yes, ma'am.
have been detained by the respondents. Same has not been released to the petitioner to request in this. Mr. EdZ Roman Learned Counsel for the petitioner, for the respondent submit that the said documents would be released to the petitioner
If I apply, my lord,
uh,
understand.
on an approach, on a representation being submitted by the petitioner in this connection to the authority wherein the said documents
Yes, yes.
are kept. In view of the above concerns described that in the matter, this court would not interfere with the order of penalty as imposed upon the petition. Same stands upheld along with the orders passed by the disciplinary appellate authority in the matter. So, however, the petitioner, however, it is directed that that the petition, however, the petitioner is directed to submit a representation before the authority wherein his educational documents are currently kept with a prayer for a return of the same. Also, the respondent authorities on receipt of such representation from shall within a period of 1 month therefrom release to the petitioner all his original mark sheets as well as certificates pertaining to his HSLC and HSSLC along with any other original documents that may be available, that were produced by the, that were produced by the petitioner at the time of his, also with due acknowledgement from the petitioner. Also, after receiving due acknowledgement of the return of such documents from the petitioner, the above observations and directions, the present writ petition stands disclosed.
Right.
In this case, why 2 counsels are required?
If it was supposed to,
Forget it.
that affidavit is not there. I am appearing. There appears
We
to
are
be
not-
some
we are not-
impersonation in this matter.
Huh?
There appears to be some impersonation by
Okay.
your lordship. As the order dated. 26/9/2016 at page number 48 of the writ.
Page number?
Page number 48. It starts at page number 48 of the,
The earlier order.
yes, earlier order.
Huh.
Lordship will see it has been filed by one Jitu Mani Das, the name of the petition, not go into other aspects. Yes, it is been filed by one Jitu Mani Das. He is saying that he had submitted representation. Yeah.
No, he has, there is another writ petition.
Yes, yes, there he is saying that on the, there was an order by a coordinate bench that his case should be considered.
Hmm.
Now lordship will see recommendation that has been enclosed to this petition at page number 44.
Hmm.
This is in the name of Jitu Mani Das. By hand, there has been an entry made which says Manav Das.
Let us see his educational
Yes,
qualification.
educational qualification. I am carrying, in fact, this affidavit in my record was supposed to be filed, but it's not showing there in the court record. I'll put this on record. Lordship takes this copy. I'll just certain aspects of this from this affidavit. I'll bring it on record properly.
That is why the advocates are not appearing.
Perhaps so. This was perhaps served on them, but somehow it is not there in the court record. If your lordship has,
Today is a day of impersonations, issue of impersonation.
I'll bring this properly on record. This is my copy. Your lordship,
Now, Mr. What purpose will serve? Nobody is appearing.
there's nobody now.
Now, what will you do? You won't get the man also. Even if we direct you to file an FIR, will you get that man? You'll never get that man. The best way is close this matter. Let us give it a closure. I thought of passing an order, but now I'll not do. We'll just dismiss it with the hope that they come with an application for restoration.
Very, very.
None appears for the petitioner on call. It is seen that with that on the last 3 dates of listing, that is on 11/8/2025, 7/8/2024, 31/1/2022, there was no representation on the part of the petition. Also, Mr. K.P. Pathak Learned, Standing Counsel, APDCL, has submitted by referring to the annexures appended to the present writ petition that there is a apprehension that the present petition has been filed by a impersonator who is trying to impersonate himself as Manav,
As Jitumani does.
as Jitumuni does, inasmuch as the earlier writ petition, which is projected in the writ petition to have been filed by the same petitioner, was so filed in the name of Jitumuni Das and not Manav Das also. However, in view of the fact that there is no representation on part of the petition, the said issue would not be permissible for this court to be examined, adjudicated accordingly on account of the default occasioning on the part of the petition in prosecuting the present writ petition, even on the last 3 dates of this court dismissed for non-prosecution. Let them come back and file an application for restoration. Then we will see. But keep a tab on this. Yes, Mr. Doctor. What is the payments? What are the rates?
I have got, I have given a copy to my learning friend.
You just tell me, Mr. Doctor.
Now, my lord, the is very clear.
Forget the rule. I want the practical thing. Please.
Yes, the practical thing, my lord, if you lost all back to 25 and 6 of the fine. Deputation.
No, I only want one thing. He went on deputation at a scale higher than what he was drawing. Now, when he went there, was his pension contribution deducted at the rate which he ought to have received in the bank, or at this stage where he was receiving as a chairman? What is the deduction?
Now, the deductions gets an higher pension.
I'm not on that. I only want that basic question answer. This court is slow, you know that. I only want that. Otherwise, I can't formulate. I can't even contemplate. So just tell me whether his pension contributions were being deducted as an assistant manager. Or let's say assistant manager or deputy manager, whatever it is, or as chairman. Scale 6 or scale 7?
Scale 5.
Scale 5, 6 or 7? Because he got 6, then he got 7.
5 in parent bank, borrowing bank, he'll
6.
6.
If he's 6 here, then 7. And that is the end.
That is that.
That is it. So he was getting 6 and 7, both.
Right.
So the deductions were being made in 5 and 6 or 6 and 7.
That deduction will be 7. But
That's the end of the matter.
There are certain things Worship you are able to pursue. Moment he gets retirement and he comes back to the parent, he will get the pension benefit will have to be computed.
Okay, done.
The,
We have accepted that.
so that
So, Mr. Doctor, what you say is that when he was the chairman, the deductions of his pension contribution was at the rate, at this scale of pay he was drawing. That means a higher deduction was there.
clarified in this guidelines.
Just a moment. Let me get the fact correct.
Fact is that small fact. What
That is the crux. So higher deduction was being made there, and then what ought to have been made by considering him to be an employee of the bank. It is not your case that although he went there, his pension contributions were being deducted by considering him to be an employee of the bank in the scale he ought to have drawn, but for this deputation. So that's the case. Okay, now what is there?
Now, Melody, your Lordship, can you see the Lordship may skip the first page
Hmm.
Lordship kindly come to sec 11 guidelines. I
Hmm.
marked it there. Lordship may see 25, period of deputation to admission in. Period of deputation. Count as. Why did the organization?
Where is that regulation? 7?
Regulation will not Punjab National Bank. Pension, it is reported, Milo. Regulation 7A is here and there. Contribution bank at the 10%. Any lordship can list the residuary.
Hmm.
Clause 56. Case of doubt in the card may be had through the central or central deputation applicable for the central. From time. Accordingly, in IVL Act, elements be reckoned deputation. Department of Banking. Where in IBA 7 of C has been decided that officer parent bank, but for the taken as what the pay actually a higher scale.
You have not done this. You have not done this.
Exactly, that is moment he retires, pension benefit will be recorded.
For the purpose of calculate and not the okay. The other way around.
Yes. But for the deputation, also from the be taken as the pay for calculating average minimum purpose of not the pay actually drawn. The loan organization.
So this is your clarification.
And there is also other things.
Okay, we got it. We got you. Got it. You mean to say whatever the pension contribution he has got, where is that the higher pension contribution that he had made? How did you reckon that?
That one, my lord, the contribution from the bank will be in the
Similar line. So higher, so was he given the, but you again calculated it at a lower stage. You took emoluments from him at a higher level, but while giving it back to him,
no, same. You'll get the same.
how will he?
That clarification is there by the IBA letter also.
Say he is there in the bank. There are two situations. He is in the bank and he is in Manipur or somewhere. Manipur. Here, the contribution is say 200 rupees at a particular scale 5. Therein at scale 6, it is 250. So he is contributing 250 each, whereas he ought to have contributed only 200.
My lord, the bank will have to contribute to.
Fine, got it. But when he came back, say he is in scale 5 only. Now it will be calculated in scale 5. This 50 rupees increase that is there, that will not be given to him.
That period, and he contributed
That,
250.
no, Mr. This contribution is immaterial. This contribution is only, this is ad hoc. This is only given, this is given for a purpose that you also have to contribute. We will also contribute and then you will get it. But when you finally make that calculation, you will make it at say scale 5.
When he come back,
At scale 5.
then after superannuation.
He superannuated there. He did not come back. He superannuated, deemed to have come back. Deemed to have. Now, what about this 50 rupees excess that was being taken from him?
That the bank also equal contribution.
No, you're not giving him from that contribution. That is only taken as a what do you call that? To certain extent to mitigate that holding. That is not the basis.
That extent, if point, my lord, we can clarify by filing an appeal. Otherwise, my lord, the law is very clear.
Now, this point that you have taken will have to be considered. That when he comes back, the contribution, the pension would be in the scale of pay.
Still fine.
Okay, fine. Okay, we'll consider that. Mr. Dasgupta, anything?
Because today I have received this thing, like one day I can look at it. I have to check it up. What he has just submitted, I have not understood anything. I have not understood anything.
Well,
Okay.
he- So that
Just-
he could
just-
study. He was sitting tight, he did not study.
No, no, no,
My
no.
fault.
That you don't say, because
I
you may
mean,
have to
because-
have some
And
instruction.
what he
inputs
has
in
stated, I have
various
not understood.
ways.
I have not
Various
understood anything.
inputs from his client also. Why should we stop that?
I
In
understand.
fact, I have not understood anything about what he has stated.
No,
I'm sorry, my English is a bit poor, my lord, possibly. That's the
the
reason.
English is worse than this.
No, no,
Don't
no,
worry.
that is the problem. You
No,
see, I have
Mr. Dasgupta, what Mr. Dotto is trying to project, you have got it. I know that. Mr. Dasgupta is not that. He can just catch anything which is floating.
He's very
But
clever.
what I have understood
Very
is,
shrewd.
Mr. Dasgupta, we have seen from our old days, the young days. What I have understood is that, be that as it may, you might get 7, you might get scale 8, but moment you retire, you are deemed to have been brought back to the department,
Fortunate.
or you come back to the department. Then the scale that is there, that you would have drawn otherwise if you were continuing in the bank, that will be taken as the basis for calculating your pension and pension. That much only. But I had gone a step ahead and I asked him that whether the contributions you have received at a particular scale, whether
asked him.
that would now be required to be disbursed in that scale, or it will be in the lower scale. Because lower scale means you are one scale higher there.
Hmm.
That has been clarified. You go through it. We have nothing, no rush here. Heard Mr. A. Dasgupta, Learned Senior Counsel, assisted by Mr.
Okay, sir, no.
D.K. Sharma, Learned Counsel for the petitioner, and Mr. S. Dotto, assisted by Mr. S. Dotto, Learned Counsel appearing for the respondent bank. Mr. Dotto has placed on record the instructions received by him from the bank authorities, a copy of which has also been given to the Learned Senior Counsel for the petition. Mr. A. Dasgupta, Learned Senior Counsel, appearing for the petitioners, he be granted 2 weeks' time to receive instructions basing on the to complete his to go through the said instructions and make his submissions in the matter. Also, prayer accepted. Registry to list this matter again. Bihur Pishodya. 34/2026. A copy of the instructions furnished by Mr. S. Dr. Learned Senior Counsel is kept on record and marked as X for the purpose of. Now the thing has narrowed down.
Well,
We'll
I shall say.
But don't say that you didn't understand. That I'll not accept. Huh? That I'll not accept.
No, I have not understood. I shall try to understand.
Please, Your Lordship. So the matter has become infructuous, Your Lord.
Salary is paid. Your name?
As Gautam, Your Lordship.
Yes, Gautam, Learned Counsel for the petitioner submits that during the pendency of the present petition, the petitioner has been granted his
Arrear salaries, Your Lord.
granted the relief paid for herein by the respondents. Accordingly, he submits the present petition. Also, in view of the above submission made by the Learned Counsel, Ms. M. Bachaji, Learned Addition, Senior Government Advocate for the response. Anganwadi worker, there were some disputes. He was working, he was not working. Now they say that he has got the full salary, so he wants to withdraw. So we have to withdraw.
Please, Your Lordship.
Mr. Singh, this will take some time. You will have
Right,
to take
right.
me through a lot of things. What we do is, we just complete till item number 20 and then come back to you. Item number 20, Kishore. Item number 20, we'll go till item number 20 and then come. Ma'am, we'll call it. We'll call it. Just wait. She comes, she's a petitioner in person, comes from Calcutta, so I don't want her, keep her waiting.
I'm not that much in hurry because my flight is at 7:10.
Ma'am, we are in hurry to see you.
No, in that case,
We will take it up, don't worry.
May it please, your lord.
Yes. Yes, sir. This is that surfacey proceeding. Yes, what is left here now?
Here, let's see, it's not regarding surface
No, they have instituted surfacey proceedings.
But
If there is some dispute, you go before the DRT. Why are you here?
only thing is that
Oh, 13.2 has been done. 13.4 also done. Now the possession taken over finally, formal possession under 14. Then what is left?
you have a very limited prayer, lordship, at least given us the.
We will not
documents
touch
relating
it
to the law.
even with a long hand. We will not touch it.
Lots.
You withdraw this, take your liberty wherever you have. We can do.
Only that much that we.
No, that is with the bank. If you want to have a one-time settlement, go ahead. But you did not follow. You made an application, you did not follow up.
Lots.
The house is taken over or symbolic position only.
I have no instruction in this case, lordship.
Mr. R. Fukan, learned counsel, heard Mr. R. Fukan, learned counsel for the petitioner. Also heard Mr. P.C. Goswami, learned counsel, appearing for the respondent. Mr. Fukan, after attempting to argue the matter at some length, considering the contentions raised by the respondents in the affidavit filed in the matter, wherein it has been highlighted that the proceedings under the SARFESI Act Pura likhi diba, 2002 has already been instituted and symbolic possession. Possession has been possession or symbolic possession? And symbolic possession of the property, of the mortgage property, of the security has already been taken. Mr. Fukan submits that he be permitted to withdraw the present writ petition to approach the bank authorities and or the appropriate forum for redressal of his grievances. Also, prayer is not objected to by Mr. P.C. Goswami and the counsel for the respondent bank. So accordingly, in view of the submissions of the learned counsel for the respondent, for the petitioner, the present writ petition stands dismissed with liberty as pre. We
Obliged.
can do nothing here.
Obliged.
What is left here?
This case, Your Lord, I have not received proper instruction. Because
Proper instruction, they have said that you have given everything now. This was on 29/1.
dispose of calamity on the basis of
Mr. S. Islam, learned counsel for the, heard Mr. S. Islam, learned counsel for the petitioner, and also Mr. A.K. Ghosh, learned counsel, appearing for the learned standing counsel, Panchayat and Rural Development Department. Also, Mr. Ghosh, on instructions, had submitted that the pension and pensionary benefits of the petitioner has already been settled, and a pension payment order in this connection has been issued by the Office of the Accountant General Assam on 6/12/2019, authorizing to him pension with effect from 1/3/2016. Also, he has further submitted that the area salaries as well as the leave encashment benefits have also been disbursed to the petitioner. The said submission made by the learned counsel for the State and Rural Development Department has not been disputed by Mr. S. Islam, learned counsel. Also, in view of the above, the present writ stands dismissed as having become infructuous. Uparot AO likhi dibade, SK Medi, AG. Yeah, we should the pension payment order. SK Medi, AG. Huh?
Obliged.
Mr. Lordship. My lord, my senior is legs in court number 3. Kindly let this matter be the just
After some time.
My lord.
Supposed to place instructions as of waited.
Mr. Mahmood, admittedly, you are not entitled. Error occasioned. And you being a person who is there in this school to process all this thing, a doubt will also arise. Okay, you got it. Now it's in the old age time. What do you say about 50% of the amount? 50% recovered, 50% you get it. Think over it. We'll take it up after some time. 50%, I'll close the matter. Madam will also, I think, not object to that.
But Supreme Court,
Syed Kadir's case, Supreme Court.
Supreme Court says the entire amount should
No,
be.
I'll when there is
Because
a
I
doubt,
discharge duty as duty.
then we will decide it on merits. I'm giving you an option. You can think over it. No, nothing. You think over it. Read 2009 3 SSC 475. Syed Abdul Qadir. Similar some situation. Read it. Try to distinguish it. Ms. D. Mushari, Learned Counsel for the...
We have judgments of even 2015.
I have that, but here, Mr. Counsel, there is a apprehension. There is a misrepresentation. You knew what you were drawing as a UD.
I knew that.
When you came back as an LDA, you should not have. And that too, when you are in a clerical staff, you know better. If it was a teacher, I would have understood. But you are a clerical staff. You know better, more. You know how to prepare, how to calculate. You know everything. Still, you did it. So, the entire amount is liable to be 45. But I'm giving you an option. Think over it, 50%.
Let it be.
No, not pressuring. Whenever you want, after the vacation.
Day after.
No. When can you get the instruction? Next week. Can you get the instruction on this 50% thing also? Nothing. Just get it. He has worked. He has got now in the old age. Why should we? He may be now living with the support of his children.
Service as an UDA.
Oh, now he may be with his children. So
Four very old daughters.
If he gets that amount,
no son.
It will be at this age. He's worked for a long time. It will be like a gift from the master to the government servant. I'm not calling it a servant, government servant. Okay. On the prayer of the Learned Counsel for the parties, the registry to list this matter again on next week, 9th? After vacation, on 24/4/2026. Mr. Mahmood, think over this.
Yes.
And Ms. Musari, you also
I
get
will discuss with my client.
you please do. We'll finish it off. There will be nothing. Otherwise, this issue will again go up. Then it will be a problem. You think over it. It's a advice. There is a Supreme Court decision on this also. 2009 PSSC 475.
And I have got also Supreme Court decision of
That is
2015.
there where there is no misrepresentation. Rafiq Mashik, Daniel, all
That
those
is,
cases you find where there is no
2015 4 SCC 334.
What is the name?
Name, of course, not that.
2015?
2015 4 SCC 334, para 18 and 19.
Therein there would not be, you have the judgment with you?
At present, I have, because perhaps I have given. And it is also reflected in the order of my Lord Justice.
But Rafiq Mashik. There is no misrepresentation in Rafiq Mashik. You read Abdul Qadir. Okay, fine. We'll see. Yes. Yes, Madam Deka. How can we help you here?
Lordship, petitioner is already retired.
Oh,
There is some amendment, needs some amendment of the prayer person and body part, Lordship. I may be allowed to amend the prayer person and body parts.
why?
Lordship, he is already retired on 30.
On the prayer of Miss D. Deka, Learned Counsel for the petitioner, matter stands adjourned for 4 weeks. Also, matter be not treated as a parted and or tied up matter with this court any further.
Amend the prayer person, Lordship.
You do whatever you want. Huh? Oh, we'll come to it. Let it be there. Nothing is there. If we allow his case, you will have to pay. Then Kimal?
Please, your Lordship. Lordship, may I kindly for pass about time being, Lordship. My senior is busy for
Yes, you have got your instructions. What is it? So, where is that guideline?
It's not available, 2024.
Who is your senior?
MD Sodori, Lordship.
Ma'am?
MD Sodori.
Okay, call. We'll take it up after some.
My guidelines also.
Hmm?
I have my guidelines also.
We'll dispose it off in that terms of that guidelines, if they agree. Because the earlier recruitment process, we can't touch now. It's gone. Okay.
May it please your Lordship.
Yes, Mr. Inga.
Your Lordship, this boils down to a narrow compass wherein
My narrow compass will make it more narrow. Tell me one thing. Did you apply for the screening purpose? Did you subject yourself to this screening?
instructions I don't have, your
I have
Lordship.
it. It's there in the records. Your services were terminated.
Right, your Lordship.
You came up and challenged that here.
No, your Lordship.
Yes, you challenged that here.
No.
There is a order. My Lord Justice Ansari's order
Yes, your Lordship.
brought on record by the respondents.
No, your Lordship.
Yes.
If your Lordships kindly read that order, your Lordship.
That order, we'll read it. Come on, let's read it together. Page 90.
91, your Lordship, it starts. Second para.
Mm.
The writ petitioners are assistant teachers of LP school in the district of Dhemaji, and they have challenged in this writ petition the order dated 9/2/2007 issued by the government and the order dated 17/3/2007 issued by the district elementary education officer, whereby it has been directed that the petitioner should not be treated to have been in service.
You are one of the petitioners here.
Yes, your Lordship. Should not have been treated to be in service. We have not been in service since termination of the service with effect from 18/5/1992. The petitioners contend that they were never served with
Okay,
any
I got
order
it.
of termination.
I got it. Be that as it may, this fact was not disclosed in the writ petition. This fact was not disclosed in the writ petition. Why?
Your Lordship, in that case, we have challenged.
Yeah, I'm not on that. I'm asking you a question.
Yes, your Lordship.
Was this fact disclosed in the writ petition or not?
No, your Lordship.
In the writ petition, you have gone and said, what is this committee? What is that? This, that, Dulu Devi and all those things. But you did not disclose the fact that it is this court which required you to be placed before the committee.
Right, your Lordship.
And you have not assailed this order. This order has attained finality. So your placement in the committee has attained finality.
But in fact, your Lordship, they have also admitted that there has been no service of termination orders upon me.
We will not go into that because that was the issue here. And this court said, nothing doing, go before the committee. You went before the committee. Committee now has appointed you as a tutor.
Yes, your Lordship.
That's the end of the matter.
But your Lordship, the admitted fact is that when you have not served me with an order of
That I
termination.
can't go into. That is already, why didn't you file an appeal here? You should have filed an appeal. Or at least disclose that fact in the writ petition. That was asked, required. Maybe the petitioner did not tell you about this. He had not even disclosed this fact in the writ petition. It happens, we know.
Your Lordship,
Practical.
let me get a copy of this writ petition. Let me get a certified
No.
copy of this writ petitions because
Certified copy, Mr.
your
Counsel,
Lordship,
Mr. Sinha,
kindly-
you have not even filed a written argument here.
No.
Sorry, written AIR, written reply.
No, I have
Affidavit
not
in
filed.
reply. You have not filed. This was filed sometime in 11/9/2020.
Thereafter, the matter was heard and it was,
Be that as it may.
your Lordship, they have themselves admitted in their affidavit in opposition that they have not served with the copy of the termination order.
We come to the conclusion that you are a irregular, illegal teacher, as you have been already placed before the committee. This big legal jargon will not help you when the facts are against you. Law will follow the facts.
But the facts remains that, your lordship, it is an admitted fact on position. Your
No,
lordship
how
will
can
kindly
I?
take.
Why should I?
Your lordship will
When
kindly.
you had challenged that order before this court on
No.
that plea, and see what this court has said.
No, your lordship, on that plea, my plea was specific that I was not served with the termination. Your lordship will kindly let us read once again, your lordship.
I got it. I got it.
My specific plea was that I was not served with the order of termination.
And the respondent's plea were also taken. Now the court requires the committee to decide this. And said that that factor, whether you are illegal or irregular, now will be looked into by the committee. That is why the matter was placed. Now the committee has looked into. Now come to your prayer. And clear suppression here. Clear suppression. Come to your prayer. Nothing. And let us see your statements. You have, Mr. Singha, you have disclosed about a case of 3819-2008, but you have not disclosed the case filed earlier to that. Maybe you have not even disclosed that here also. Where is this order of this court? 9, Annexure 9. How you have, your clients have misled this court. While this order was passed, 3819-2008 on 9/12/2015, the earlier order passed was never brought to the notice of this. Or is it brought? Or is your client's contention that that order is of no use? We need not even refer to that. What is that order? And see how you have, you filed a contempt case also. These petitioners should not be given any benefit. Rather, now for that suppression, we'll have to drop. We have to impose cost on him. Teacher.
Your lordship.
No, teacher. And behaving in this manner.
Your lordship will kindly appreciate one fact of this. 16634 was brought on record saying that I have challenged it. But in that case, your lordship, I have categorically there also stated there that the termination order was
another thing. That you have, in pursuance to the order of this court, appeared before the committee, submitted application, appeared before the committee considered your case, and thereafter did this, then a challenge to that. That is also not there. You have not even referred to that in your writ petition. We will apply Dulu Devi, no problem. We will apply the earlier round of cases also. And I'm personally aware of those propositions. But in a case where there is suppression, do you know how it came to my notice? As you were appointed as a tutor, so that means you had that screening committee would come in. So I have found cases wherein, without even appearing, they were said that they had appeared and they had passed orders. So I made a scrutiny of your statements. When I did not find it, then only I went to the affidavit. Therein I found this. Then it came as a shock. But a teacher is suppressing facts before this court. Two facts. 2007 writ petition and the screening committee process. But Mr. R. Singha, learned counsel for the petition. I'll not take you by surprise. I'm giving you an opportunity to prepare. This is just a tentative view I have taken. You prepare. Mr. Fukan is already in trouble. Let him not be put to more trouble. R. Singha, learned counsel for the petition. Also heard Mr. A. Fukan, learned standing counsel, elementary education department. Also, this court on perusal of the writ petition along with the affidavit filed by the respondents finds that the petitioner in the affidavit in the writ petition has not even referred to a proceeding instituted by him before this court being WPC number 1634/2007, which was disposed of by a coordinate bench of this court by order dated 9/5/2007, referring the grievance of the raised by the petitioner to a committee constituted in the matter in terms of the decision of this court in WPC number 2844/1999 and other analogous matters, and as well as the judgment and order dated 6/4/2006 passed in WPC number 2147/1999 and analogous matters. Also, further, this court has found that the petitioner being appointed as a tutor from such appointment was in pursuance to his case being examined by a committee constituted by the said committee as constituted in the matter. However, there is no reflection. However, there is no disclosure of the same in the writ petition by the petitioner. Also, the learned counsel for the petitioner examine the said aspect and make his submissions in the matter on the next date of list. Registry to list this matter again. What we should give?
Your Lordship will keep it as for further hearing, Your Lordship.
After applying so much of time, wasting so much of time, why will I not?
No, therefore I'm saying.
28/4/2026 for further hearing. Mr. Singha, this is just tentative. Try to now make your case, and I want you to argue this. I want that thing. Why? If not, ask your client that this is going to happen now.
Definitely.
Withdraw the matter, I'll let you go.
Deeply obliged.
I was asked to obtain the application form of the private response. Got it from the database.
Anything more, madam?
Lordship, my senior is coming, Lordship.
Okay, we'll take it up. This is of the respondent number 3. This is of the private respondent.
Yes, my lord, private.
And your case with him is that 20 marks is not entitled because he was not working as a dresser. Yes. What has happened?
There are instructions.
Other than no instructions, you can make any submissions. Then today, if there is no instruction, it will be very harsh. Very harsh. Because the petitioner in person for this matter is rushing down from Calcutta. I had asked her not to, but she, because of her eagerness, naturally, she is here personally.
Lordship, it's been 3 years I have
3 years.
passed in this
I
court.
know that.
It should not preclude for the interim order in that case, Lordship. At
You're
least
getting your provisional pension.
regarding not the provisional pension, at least proportionate pension can be sanctioned at this stage because
Madam, that
Lordship,
is
with all
why
humility.
my hands are tied. That is why I'm pursuing the matter with the respondents. Because until and unless that relaxation is not given, the rules prevent you from getting a pension.
I oblige, Lordship, but in that case, Lordship, where I have worked in the Assam government and it's a substantive and it was permanent and it was being paid by the government, in that case,
Madam,
for
just
this
a-
interim order can be passed, Lordship.
Yes. Today, 2 o'clock. I want that instruction. Sorry. We have been dragging this matter too long. Either I dismiss it or I allow it, but I want to do it. 2 o'clock. Why you have not exercised the power of relaxation? Reason for that. And if you contemplate to exercise it, the period you will take. These two instruction, either or, give it to me. Madam, we'll take it up at 2 p.m.
Obliged, Lordship.
It'll be a little bit late. It'll be 2:15.
Only thing, Lordship, with all humility, my flight is at 7:10. So it would take 3 hours from here, I believe, in the airport. So 2 will do, Lordship. Nothing will happen.
2:15 I can come back. 2:15.
Obliged, Lordship.
So you will have to reach by 5. 7 o'clock flight.
Yes, Lordship.
And we are compensating her for your default. This order was passed on 9/3.
9th March.
9/3.
And before that,
And
also,
before that,
similar order has been passed, Lordship,
too.
with honorable other judges of the same court, Lordship.
Okay. We will now, it's 11:30. We will try at 1 o'clock. Get
Obliged,
your
Lordship.
instruction. 1 o'clock, madam. And madam, if the instruction does not come, I'll ensure that her flight tickets are paid by you. Issue is same in both, my lord.
Judgment away.
Oleh mati di sini. Ibu di mana lagi ini? Kalau mati di. Yes, Mr. Singh.
I have been, my lord, I am working as a Safai wala. Sir.
Yes.
I have been working as a Safai wala since 2012. And
We are taking Ganesh Kormakar.
my lord,
And you're working as on date also? No.
my lord, yes.
Working.
My lord, since 2012 January, to be specific, I am working.
Just a minute. You're working from?
16th of January, I joined, my lord. 2012,
5/1 is your appointment order.
on 5th of January, my lord. 2012.
Where were you appointed?
Air Force Station, Mishamari, my lord. The district of Shonitpur. Now, my
And
lord,
joined on 7th.
joined on 16th of January, 2012. 2012.
Okay.
My lord, in September 2015, I
Oh, sir.
got a so-called notice saying that I had submitted forged HLC certificate. The so-called notice was dated 4th of September 2015, my lord. I immediately replied back, my lord. The matter ended there. In March, on 14th of March 2016, I received,
When did you reply?
I replied, my lord, next day, my lord,
15.
They have provided the copy, my lord, of my answer.
What 16.9?
Yes, my lord, 16.9. Next year, my lord, on 14th of March 2016, I received another so-cause notice with the same set of allegations that I have produced forged matriculation certificate in order to get employment. I submitted my reply, my lord. Thereafter, on 30th of
Just a-
March,
Then you
thereafter,
replied on 15.
my lord, on 30th of March 2016, my lord, the charge sheet, a memorandum of charge sheet, my lord, containing the imputation and allegation against me was served on me. Annexure 5, my lord, page 53.
Lecture 5, page 50.
It is page 53, my lord. It starts at page 53. Now, my lord, kindly come to page 57. Annexure 4 to the memorandum of charge, my lord.
Page 54.
57, my lord. Who was going to prove the charges, my lord? Presumed
Fine.
list. The OIC Civil Administration, his name is there. Now, my lord, basic allegation against
So
me.
your case basically is that because there was a, your case is that because there was a show cause notice issued on 4/9/2015,
15,
that you submitted a reply, nothing happened. So that was the end of the matter. You could not have initiated.
No. My contention, my lord, is that thereafter a full-fledged inquiry happened in the year 2016.
Okay, then what happened?
Thereafter, my lord, they informed verbally, my lord, that you have been acquitted of all the charges. 2 witnesses recorded evidence on my behalf, my lord. No witness was brought by the by the inquiry officer, before the inquiry officer, by the presenting officer, my lord.
Where is that? There is no order for that effect.
No order. And my lord, I have made a prayer in my writ petition that the respondent's authority should at least produce as to what happened. If they say that I was not acquitted, at least they should produce what was the ultimate conclusion to the inquiry. Very unfortunate, my lord, is that
okay, fine, forget it.
Then
Then what?
till date, they have not produced.
Then what happened?
Thereafter, my lord, I was showing, my lord, page 57, who was supposed to adduce evidence.
Mr. Singh, we got it. That proceeding, nothing happened. Then
No,
what happened?
no, my lord, that happened.
Inquiry happened, it did not go to the logical conclusion.
In our humble...
we got it, Mr. Singh, that you were informed that you were acquitted.
Acquitted.
Fine. Then what? You are only a Safai wala in there. Organization. How can you go against these powerful officers? So you had sat down tight. Then what happened?
Thereafter, my lord, in 2018, in 2018, my lord, I received another third show cause notice, 12th June 2018. I responded to that letter, my lord. If
Now,
your
where
lordship
in
come
this
to
response have you written that you had
my lord,
appeared?
kindly come to page 72 and 73, my lord. Page 72, my lord.
74.
74 is my answer, my lord.
Okay.
And here, my lord, I made a categorical stand that the earlier inquiry officer Rajveer Singh was there. He did the investigation, concluded the
Para 7.
inquiry, my lord. And kindly come to para 13 of my reply, my lord, of my answer. Page 78, my lord. The third so cause which I responded to, my lord.
Okay. Then what happened?
Page 78, my lord, para 13 of my.
I've read it.
So I made it a very categorical stand, my lord, that the
So
earlier.
the fresh proceeding was thereafter instituted by page 80.
My lord.
And this is the one now where you have been thought to be punished.
No, my lord.
No.
Again, this was dropped.
This was also dropped.
This
Then
was
what
dropped.
happened?
When every year I receive show cause notice, my lord, the sword is still hanging. So this is the fourth, my lord, the show cause notice.
No. The memorandum, this is the second memorandum.
No, my lord.
Page 80.
There we have committed an error, my lord, in this case. We have annexed wrongly 30th March. Kindly see, my lord, page
30th
80.
March 2016.
But the second case we have annexed correctly, my lord.
What is
It
that?
is 2019, my lord, actually. This
What is this 33 2016 then?
page 80, my lord, the first page and second page erroneously we have annexed of the previous.
Okay, this should be
Memorandum.
2019.
But if you
Same
kindly,
document has come twice.
Huh?
Same
Uh,
document has come.
but
Okay,
if you
what is the
lordship come
date
to
of-
page
what
84,
should
my
be the date of 80?
This is 18th March, my lord. Yes, 2019. If your lordship come to page 84, the correct page is there, which is part of the memorandum, my lord. It is 28th of March, 2019, my lord. This I responded by,
18/3/2019. Second one,
this is
page
the
80 should be 18/3/2019.
28th March, my lord.
20?
28/3/19.
2000? Okay, where do I get it?
Page 84, my lord. And in this second writ petition, which is item number 12, the correct annexer is there, my lord.
That is some
Biren Daimari, my lord.
he is also similarly situated.
Similarly situated.
Second writ petition page.
Page 86, my lord. There, page 86. Now, in both the cases, the response was immediately given on 7th of April, 2019, my lord. In the first writ petition, if your lordship is looking, page 85, the answer is there. Now, in the
54.
second,
5/4/2019.
5/4, my lord. In the second paragraph, my lord, I have referred to the previous
Yes.
board of inquiry, and I have also prayed as to what happened there and what was the ultimate conclusion and why the new press board of inquiry. There must be some reasoning, my lord.
They can't go on having inquiries.
My lord. Next page, my lord, page 86, a full response is also there in the form of my written statement, which is nothing but continuation, my lord. So, by the first letter, I have prayed for the
Reasons.
and also,
And you said that this
also
was
requested
also
my
not-
lord to provide me with a copy of the first board of inquiry conclusion or what
Fine.
happened there.
Now, this was also not taken to its logical conclusion.
No, my lord. Thereafter, what happened? Kindly come to Annexer 18, page 91. Second para, it is intimated that the above letter we treated as cancelled due to administrative reasons.
This is dated.
This is dated 18th November 2019, my lord.
Then what happened?
Thereafter, my lord, I wrote a letter, page 92. asking for providing me with the final conclusion which was arrived at in 2016. This perhaps irked the superior, my lord. 19th December 2019, my lord. Because every year, my lord, I was facing inquiry.
Then what they did?
Thereafter, my lord, since there was no response to that, I
You
made
submitted RTA
an
and all.
RTI, my lord.
Oh.
And I
Where is
continued.
this? A third show cause notice, memorandum now?
That is, my lord, page 98. Is annexure 21.
Where is the memorandum preceding this?
This is the memorandum, my lord.
No, this is not
Inquiry.
the- This is the inquiry.
Inquiry, my lord.
Where
Yes.
is the memorandum? preceding
That
this?
is, my lord, after my answer, they provided, it is. Acha, acha.
Where is that memorandum preceding this page 98? What happened in person?
Yes, my lord. My lord.
Where is that memorandum preceding?
That memorandum is not there, my lord. Why it is not there, I am explaining. Thereafter, when I made the submission, my lord, in writing, page 100, and you see 13th of July 2020, the so-called which I answered, my lord. And I also side by side prayed for providing me the conclusion of the earlier inquiry. Thereafter,
Just a moment. Okay, 100.
100, my lord.
This is
Thereafter,
your reply to the inquiry,
My lord.
the holding of the inquiry.
my lord, thereafter on 103, your lordship will find that they asked me to appear before the board of inquiry. Till then, I am totally ignorant as to what is happening, my lord. Para 2 says that I shall hold a preliminary hearing in the case on 17th of July. I am reading, my lord, page 103, annexure 23. Para 1, with reference to station commander's order dated so and so 9th of July, a copy of which has been endorsed to you, the station commander so and so has appointed me as the inquiring authority to inquire into the charges framed against you. Para 2, I shall hold preliminary hearing in the case on 17th of July in room number so and so at 10 hours. You are therefore required to attend.
Then
Thereafter, my lord, next date 17th
Same
of
thing.
July, page 104, the summon was again issued to me.
so memorandum is dated 30/3/2016.
Next page, for the first time, I was informed, my lord, page 105, that with reference to annexure 3 to memorandum issued, right, so and so dated 30th March, please find the list of additional document received from SEVA and its copy. So previous correspondences doesn't disclose, my lord, as to what was happening or what was going in the mind of the officier, be it the disciplinary authority or the inquiry officer, my lord. The first time it was disclosed that this is
Sir, we got-
perhaps, my
then,
lord.
Then.
Thereafter, my lord, the additional document that they have enclosed is of 5th of December. Kindly come to the next page, my lord. Come to the next page, my lord, page 106. The additional document that they have talked about, my lord. This is of dated 15th of December 2019.
105.
106, my lord.
We got it. It's an earlier document.
Now, my lord, the inquiry, board of inquiry is of 2016. They are now relying on a letter which is of subsequent date, that is of 5th of December 2019.
There is no harm there because that is a subsequent thing. That is why they wanted to bring it as an additional document.
No issue, my
Now
lord.
tell me what happened in person.
Thereafter, my lord, this is the letter on which they place reliance. This letter purportedly has been issued by SEWA. None of the official was ever called either during the 2016 or in 2019, nor any officer from the Air Force Authority made any sort of
You mean
evidence.
to say that the
This is a case
documents
of
were
no evidence.
exhibited, but the contents were not proved?
Not proved, nor any official from Air Force who might have collected these documents. He was asked to enter into the witness box, my lord, and to adduce
So
evidence.
finally, what happened after this?
This is
After
only
the
tendered.
inquiry? After the inquiry?
After the inquiry, we responded to the inquiry, my lord, and thereafter.
What happened? What is the
The
final
inquiry,
conclusion?
that is at page 140.
One?
109. My lord, my younger brother is making that let us not jump to other pages. 109 for a moment, my lord. Your lordship will find that
I'll come to that. I'll come to that. Don't worry. But tell me what was the inquiry report? Any
the
inquiry?
inquiry, yes, my lord. The
Where is that?
inquiry, that is at page, my lord, 157.
157.
Final inquiry report, my lord. It starts at page 156, my lord, and the relevant page is
Okay,
157.
then there was a copy of this given to you?
Yes.
You submitted your reply? What happened thereafter?
Thereafter, during the pendency of this fresh board of inquiry, my lord, we had approached this Honorable High Court by way of writ petition.
That was stayed?
These subsequent, no, not stayed till then, my lord. These subsequent developments were then brought to the notice of the Honorable High Court. We amended the writ petition.
Then what is any penalty, order of penalty passed here?
Thereafter, no coercive action was taken, my lord. No penalty.
No penalty.
This is
160.
My lord will take note of the fact that on 6th of August, I had submitted my written statement. And
Where is the inquiry report?
page 157, my lord.
157.
May I read this, some of the relevant portions, my lord? The first paragraph, my lord. if
Just
I-
give me 2 minutes. You had adduced some defense witness also,
Earlier, my lord.
not in this proceeding.
No, my lord. Because in the fresh board of inquiry, my lord, there was no evidence from the side of the inquiry.
Yes, Mr. Person. How did you establish this? The inquiry.
In our affidavit, we have replied in paragraph 4, paragraph 14 and 17, that
What?
they are trace inquiry, inquiry. Then no, how can they clearly from that it has been completed and he will be.
We
able to call-
forget that first one. The second one, how did you prove this charge?
They're all further inquiry. Hang on.
There is no fresh memorandum
No
issue.
phrase, no
The
phrase.
memorandum that you issued in 2016. 18, the first memorandum is of dated
30th March 2016.
Mark to the-
30th of March 2016. 30th of March 2016. So this is further inquiries. Huh?
In the final report, my lord.
Okay, the inquiry, the earlier there is no inquiry report. So
No
this is the accepted inquiry report.
Yes.
Now tell me from this inquiry, so 33 2016 culminated in the inquiry report at page 150, 157. Now, how did you prove the charge against it?
This document, my lord, yes.
The document, only by the document. Who produced the document?
The Seva authority.
Who produced it before the inquiry officer? Done. If the document can speak for itself, why an inquiry is required? Your officer can do it. Why require the people to?
My lord, but
Oh, no, nothing, no material. Where is the inquiry proceedings report? The report we have, the daily sheet, proceeding sheet. Get it. Get it. Second off. Summary. Oh. And we could have asked Mr. Singh when he was coming down to you to collect it also. Did not tell us before that.
Today, my lord, Honorable Defense Minister is there. So every road is chalked.
Now tell me, if that is not proof, the whole thing goes. That means documents cannot just be produced because he had also produced documents. Reports from the SEBA. You have rejected his documents by saying the English language written there is not correct. You have not examined anybody. Mr. Singh,
My lord.
all said and done. What is the actum of your matriculation certificate?
I have actually passed from, as a private student from Rangapara Higher Secondary School. They are asking for regular certificate for a regular student from the Seva board, my lord.
What is
Not
your
for-
roll number?
I have provided, my lord. Just a minute, my lord.
The SEBA cannot reply whether you applied from this or this. SEBA will reply only with regard to the appointment, the roll number. Right. Nothing more, nothing less. Where is your matriculation certificate here on record?
Exhibit 1, my lord, Annexure 1, page 40. Roll number B07-462, number 0531.
And where is the report relied upon by the, you have brought that on record, Mr.
No, they have not brought, my lord.
Huh? The affidavit? Either affidavit, your affidavit or his? 20? Two 08.
One. Proceed.
Page?
One.
Can you, somebody send for Mr. T.C. Chutia? Seba. 196. Okay. And where are your reports that you got from the Seba, Mr. Singh?
My lord,
Your reports from Seba?
I called witness, my lord,
No,
along
no.
with records.
No.
Those records are with them only now.
No. The inquiry officer says that you also produced a report
My lord,
from
that
the
is what I am saying, my lord. The official came with reports and they are in their custody, my lord.
official of the Seba.
From school, my lord.
Okay, this is a very small fact. Why we delayed? We can get the matter inquired from the Seba itself. And
Lord,
if you have produced the forged certificate, no proceeding is required. Latest decision of the Supreme Court in Vinod Kumar. Justice, my lord. Last judgment.
My lord.
Latest judgment came a week or two before. If a document is
In the meanwhile, why not they submit the report, my lord, of 2016, number one? Number two, my lord.
We'll ask Mr. Chutia, we'll request Mr. Chutia to also do that exercise. And if that report, if they stand by this report of theirs, that's the end of your. Where is Mr. Chutia? Let Mr. Chutia come. Last time when I considered this issue, I was on the question of Rup Singh Negi, applicability of Rup Singh Negi here. But after having gone through the Supreme Court decision, now the Supreme Court is very, that no leeway is to be given. That's the end of the matter. In a defense force, Modi. Vinod Kumar.
Otherwise,
CT
my
Vinod
lord,
Kumar.
so far, whatever my brother comes and inform the honorable court,
We'll follow
I am
that.
not opposed to any board of inquiry, but it should end at some point of time, my lord.
That we will ensure. And if we find that your certificates are genuine, we may even impose cost on them for the trouble that they have caused. Let Mr. Chutia come, we'll take it up. You have got the records, Mr. Not there. Nothing is there.
So I have asked for certain documents, original file.
You had this on the last occasion. Now why this is gone?
Last occasion, my lord, joint director, my lord.
When did it go missing?
Last occasion, my lord, joint director, my lord, he wrote to me, my lord, I have, you are suffering from so he could. Now I asked the secretary, my lord, from which, my lord, from the file of the council, my lord, the release order was issued, appointment order was issued. Lordship, look into my order, so I raised my lord 34 points, my lord.
Okay, wait. This will require now hearing. Not India. Steno, India, would you? Heard Mr. A.M. Barbi. Learned Counsel Petitioner. Heard Mr. J. Chutial. A is Learned Counsel. Also heard Mr. AAC. Mr. Chutia, Learned AAC has placed on record communication issued by him for a requisition the records from the Secretary, Health and Family Welfare, K. However, while communication dated 34,006, Mr. was informed that the file wherein they said records were is missing, and committee has been constituted to inquire into the matter and therefore has prayed for 20 days time in the matter. View of the such stand taken, this court provides a last opportunity to the KAAC authority based on record the records as called for. To facilitate placing of the said matter adjourned and adjourned today, is listed on Seven 5/2020. No further adjournment shall be granted. Wait, we'll see. Let us see how far they will. Yes, Mr. Chutia. I request you. No, Mr. Chutia. Our senior Chutia. We request your help here. We are giving you 2 roll numbers, and they'll give you your earlier reports. We just want you to verify that and give it in a seal cover. And further, whether in this connection, you had not taken any report from the SEBA authorities. What is this?
We had brought from the school, my lord.
No, what is this 157 then? Okay, we'll see. Heard Mr. SKC, Learned Senior Counsel, assisted by Mr. A. Ganguly, Learned Counsel for the petitioners in the above noted 2 writ petitions. Also heard Mr. Parasar, K. Paraskar, Learned CGC and Ms. A. Gayan, Learned CGC, appearing for the respondents in the above noted 2 writ petitions. Also, the petitioners in the above noted 2 writ petitions were charged of having joined their respective services by producing forged /fake HSLC pass certificate. Is there a high school leaving certificate private examination? There is no private examination.
As a private candidate, my lord.
Candidate only. There cannot be a private examination.
No, private.
It is, you see your certificate, that itself shows. Page 3023.
Kunda.
Just show Mr. Chutia the certificate. Is private, this certificate issued in this connection manner private? Private, I don't think so.
The private institution.
Candidate. Board. But that is only one examination.
What examination?
There is no examination called private examination, regular exam. Candidate is private or regular?
Yes.
Oh, yes.
Yes.
Mr. Singh,
My lord.
the client's very in trouble. Okay. Eligibility. HSLC pass certificate. Post with the aforesaid. The department has sought to establish the said charges basing on reports received from the then SEBA authorities, SEBA. Also, in view of the said position coming on record This court had requested Mr. E.C. Chutia, learned standing counsel, Assam, what is it?
State school and
Assam State School Education Board to verify, to have the said board verify the HSLC bracket private examination, 2007 certificates produced by the petitioner, annexed by the petitioner to the present writ petition, which is also contended to have been produced before the authorities at the time of their respective initial appointment. Also, the learned counsel for the respondents, Mr. You give him, shall submit Xerox copies of the HSLC bracket private examination, 2007 certificates produced by the petitioners in the above noted two writ petitions, along with the reports as available in record, as brought on record pertaining to the reports brought on record with regard to the verification of the said certificate by the SEBA authorities. Also, Mr. Chutia, learned standing counsel, ASSEBA NECBA, shall require the respondent, shall require the HSD authorities to carry out a verification of the said certificates and submit a report thereof to this court through him on the next date of listing. How long will it take, Mr. Chutia? Mr. Chutia, how long will it take?
1 week, Madam.
Okay, we'll have it after Bihus. Bihu. You're going somewhere. No, you're going out international somewhere. You'll be in India. You'll not be in India.
Mr. Sir, during the vacation.
Vacation.
No problem, I will.
You come back. Okay. You'll be in India or you'll be out. You normally are out of India. That's it. Old roots. List the matter again on 24 would be fine with you. 20 will be fine with you, Mr. 24 for 2026 for further hearing. You give him the certificate. No. Give it together. Certificate along with the reports. There are reports there. Give Xerox copies of that also. Both Ms. Gayan and you, both of them give it. For further hearing, both Mr. Singh will see. And if the reports come against you,
And if the report comes against me, my lord.
then to finished. Mr. Chutia will do the needful. What are you waiting for, Mr. Chaudhary? You are wanted in many places, so you don't have much time to sit here.
My name is not reflected.
Where?
It was given to me yesterday.
Which one? That's academic scale.
Yeah.
You are appearing for?
Been requested to appear for the teacher.
Well, two matters. Just one. Yes.
Lord, these three cases, I appear in item 24. This three cases, my lord, all pertain to, my lord, pay parity among vocational teachers. Lord, while, my lord. In
It's
fact,
not there.
common instructions, my lord, as per the orders, my lord, are not complete as of now. They have not been able to, they say that we have sent the proposal for, my lord, equivalence, but then in what terms and when it
Are
will
you
take effect.
regular?
my
You're
lord.
not regular. You are ad hoc.
Regular, we are regular, my lord. Only thing is that
Okay.
people who had come subsequently, they are given a
But the
gratuity of
learned counsel
2400.
for the parties. A prayer is made on behalf of Mr. B. Heard the learned counsel for the petitioner. Prayer is made on behalf of Mr. B. Question. Learned standing counsel, secondary education, and for an adjournment in the ground of personal inconvenience. Prayer accepted. Registry to list this matter again on when?
28, my lord.
28, my lord. 28 April.
28/4/2026.
28, my lord.
Mr. B.
28.
Gogoi, upor likhi pare, heard, also heard Mr. B. Gogoi, learned additional advocate general, appearing for the finance department. Additional advocate general. Have you gone through the brief?
I have gone through the lordship.
No, if you are not gone through, you go through, fine.
Lordship, I need to file, put it on
Record.
Finance.
Only thing that reason.
that. There was a good of management. So findings were missing the team.
I only want that clarification.
Say,
Bring it on record. Mr. R.K.D. Chaudhary, learned DYSGI, has submitted that he has been instructed to appear on behalf of the Tezpur University respondents. Accordingly, he submits that he be granted 2 weeks' time to bring on record the clarifications in terms of the query, clarifications to the query raised by this court-wide order dated 6/3/2026. Registry to list this matter again on when? (22/4/2026). Oh, so, madam, you are appearing for? Miss R. Devi appears for respond number 4. Oh. Is for the Miss R. Devi for the respond number 4 is okay.
May be, Lordship, we have recently engaged senior counsel, Lordship. May be adjourned for
On the prayer of the learned counsel for the petitioner, registry to list this matter after the ensuing Bihu vacations.
Date may be fixed, Lordship.
Date was fixed today. Yes, Purnima Aure, what more is required?
my lord, file the affidavit on 25. My lord, if your lordship sees, my lord, he comes under the third category.
Oh, he was that committee.
Yes, your lordship. Yes, he participated in the committee. My lord will come to.
Yes, Mr. Kulta, where have you
I
stated?
have filed reply, my lord.
Where?
That is, my lord, page 85, my lord.
85.
Yes, my lord.
Where have you dealt with that?
Yes, my lord. That is covered by the, my lord, Babul Ali, my lord.
Where is that?
Yes, my lord, page 85.
80?
85, my lord. Para 4, my lord.
Where is that Babul Ali judgment?
Yes, my lord. I have quoted also at page 86, my lord. Page 86, my lord. And I annex also, my lord. Page 86, 5, my lord, column number.
No, you don't have a judgment.
Yes, my lord. Judgment is from page 95, my lord. And relevant portion is page 96, my lord.
Where is your case? Your case.
My case is, my lord, in my petition, my lord,
Where?
page 43, my lord. In my petition, my lord. Page, my lord, 36 from 36, my lord. And relevant portion is page 38.
This is that stipend Purnima Hore.
Yes, ma'am.
Okay. Huh? This is Purnima Hore. Huh. Then you are a petitioner in Purnima Hore.
No, my lord.
Then?
No, that is, my lord, in page 38, page 36, my lord, in 2015, my lord, I covered Babul Ali, my lord.
No, where is that decision 36?
Yes, my lord.
Dhuleshwar Borwa, what is your name?
Dhuleshwar Borwa.
Dhuleshwar Borwa, okay.
That is, I am not illegal teacher, my lord, as per this order, my lord.
Where? Which order?
Yes, my lord, as per 36, my lord.
36. Where is the
Yes, my
question
lord.
of legality gone into
That
here?
is on Babul Ali, my lord.
Babul Ali, are you covered by Babul Ali?
Yes, my lord.
Where?
Yes, my lord. Page 39, my lord.
39. Then why did you go and submit yourself to this screening process?
Yes, my lord. That is my lord, fact, my lord. My lord, they have invited me, my lord, and
No, but they will not invite you without application. You submitted application.
this judgment was, my lord, passed after, my lord, screening committee's, my lord, report, my lord.
You're not entitled.
This order, my lord.
And you are now regularized as tutor. No regularization.
Oh, my lord, I am appointed as teacher, my lord.
Teacher.
Yes, my
Now,
lord. Yes,
again,
yes, my lord.
21.
21.
Where is that order?
Yes. Page 40, my lord.
So this is under challenge.
Yes.
Where is your, and you have submitted your everything in terms of this, you're getting your salary after that.
Yes, ma'am. He's getting salary, my lord, from the petitioner under terms and conditions and in his service at Rajkar Ali LP School and was drawing monthly salary regular basis from the rate of his accommodation.
Okay, where have you stated that in the meanwhile you have participated in the screening process?
That is, my lord. Yes, my lord.
Okay. Right.
Yes, ma'am.
Okay. Anything more?
No, my lord. It is, my lord. Yes, my lord. My submission is.
I think, my lord, that rule, my lord.
Babul Ali's judgment is page?
Page 95, my lord. In my affidavit, my lord. Affidavit in reply, my lord.
My lord, the initial appointment which was made to him, my lord, he was appointed by the then deputy inspector without any selection process against non-existent postmen. Against Rule 3, my lord, of the 1977 rules, my lord, which provides for method of recruitment, which provides for public participatory selection process by issuance of advertisement. He was appointed, my lord. Thereafter, my lord, he has participated himself and joined, my lord, moderated the TP.
Page 95, para 5, my lord.
A. Hussain. And when were you given the scale of pay onwards? Which date?
Yes, my lord.
Where is your JPT?
Regular.
When did you complete your training?
Yes, my lord. Basic training completed, my lord, page 22, my lord. In the year 2001, my lord. Hereafter, my lord, regular scale of pay was given in the year 2002, my lord. Page 23. With effect from 2001, my lord, regular scale of pay was.
Why 2001?
That is from 2001, my lord. Basic training completed in 2001, my lord.
No, you completed in 2000.
Oh my God, but my lord,
This is to certify that as passed in the month of December 2000.
2000.
Under even placed in the
Result
second
declared
division. The
on
result was
21/7/2001.
one.
Now you are being given from 12/6/2001.
Yeah.
1 month ahead. How?
In this regard, my lord.
This is the beauty that was there in Sipsagar. This is what Dhemaji.
Sipsagar.
Sipsagar.
That is.
Dismissed. Very good.
But my lord, popularly covered, my lord, already decided in our case, my lord, that we are not illegal teacher.
Where is that finding in your case?
Yes, my lord.
Your case, only the ratio was taken. There was no finding recorded that you are also not an illegal teacher. Babulali, you are not a petitioner.
But
That
yeah,
ratio,
thereafter- yes,
that
my lord.
facts don't get covered. It is the ratio of the judgment that comes.
Yes, my lord.
But the facts were verified.
Yes, my lord. Page 43, my lord, 610, my lord, teachers were, my lord. Here, my lord, 610 post has been retained by the government, my lord. Page 38, my lord. For a while, my lord.
Mr. Show me the advertisement. Okay, I'll accept. Show me the advertisement.
No advertisement was.
Then,
Yes, my lord.
then. Show me the advertisement. Show me the call letter. Show me those things. I'll accept. I'll accept. Come on, tell me.
That is not there, my lord.
So how have you been appointed? How were you appointed? Picked up from the road by somebody? You never sit in a AC room. Never appeared for an interview. We are only dismissing it. We are not going a step further. Dismiss. Yes. I've already dismissed one case. That's why.
Obliged, my lord.
20? Yes, Mr. Deka.
Hello.
You have brought on record those things, your clarifications.
Everything is there on the.
So pleadings are complete. This is not a matter now. We'll hear it after the ensuing Bihu vacations. Aram se.
That is Lordship will fix the date because for some reasons, my lord, we have not filled up the post. No bar.
There is no bar.
There is no bar.
That is your self-imposed bar.
Yes.
It is stated that the pleadings in the matter has been complete. Is complete. So accordingly, registry to list this matter again on. What date did you observe?
Or 30th.
30th. 34. 2020. Admissions and endeavor would be made to dispose of the matter on the next.
Obliged, my lord.
Next.
Pleadings complete.
Yes, your lordship.
You under relaxation.
Yes.
Whether it is for asking.
Yes, your lordship, because contemporary employee,
That is different.
he got it.
Illegality, we cannot apply negative equality.
I
The thing is, what is the procedure?
Your lordship, otherwise, if he is eligible, and if he applies, and that was actually
Anybody
turned down.
junior to you have been granted this? No.
NFU.
This permission?
No.
NFA, no.
NFU, yes, but that,
Haddi
that
Lana, we will hear it for.
yes.
Haddi Lana Council for the petitioners. It is submitted that the pleadings in the matter is complete and the matter would be considered, be taken up for final disposal. Give me a date, both of you.
Lordship, April 29th.
On the prayer of the Lana Council for the
30.
28.
28.
On 28/4/6. Give me a small note before that if I'm taking up,
Yes,
just
sir.
with the decisions that you would.
Yes, sir. Actually, that whole concept actually emanated from a Supreme Court decision.
NFA,
And no, that relaxation.
relaxation concept.
Here we have not.
What is that, sir? What is that case?
Lordship.
You just give it a piece of paper. For my
Yes, Lordship.
Yes. Yes. Rotneswar does record. Why? Okay, you have filed an affidavit.
No, they have not filed it.
Respond number 7.
Oh, that is the IO affidavit. Nothing rising.
No, that is a Vorolumuk case.
Lordship. Lordship, since the notice on interim relief was issued in June 2025, if they do not have any objection, I can be reinstated in the interim.
Okay, where is your shokos? Where is the suspension order?
Lordship, the suspension order is at page 111. The last page of the petition, Lordship. The termination order, Lordship.
Last date we had fixed this matter for final disposal.
Yes, Lordship.
Records. That is 1 month back.
Letter also sent.
Okay, they will suffer. What to do? I'll note it.
Otherwise, also, Lordship, in none of the documents, any specific allegation against me, Lordship.
That is different. Where is your suspension?
The suspension will be at Lordship, page 89. Was passed after 15 days with effect from 15/12. Order was passed on 13/1.
You were placed under arrest on
Arrest on 15/12/2023, Lordship.
15/12.
Lordship. Vorolumuk PS case number 357/23.
Vorolumuk PS case number
357/23. The magistrate itself granted bail on 30/12.
Then
Magistrate granted bail on 30/12, Lordship.
where is that bail order?
The bail order will be at page number 72, Lordship. In the police remand, it was more or less clear that I am not involved, Lordship.
Okay, then where is the suspension order?
Suspension, Lordship, has gone through at page 79. 89, Lordship. The 90 will be relevant, Lordship, page 90A, paragraph 2. This was a report submitted by the IO. Page 90A, English translation, paragraph 2, Lordship.
No, forget it. Then what happened? The show cause scheme.
The show cause scheme,
concerned with the criminal case.
Lordship.
92.
Yes, 92, Lordship. 27/3/24. Then I submitted WS, Lordship. Then the inquiry report came, Lordship.
Enquiry held.
Yes, Lordship. Completed.
Enquiry report on
102, Lordship. The findings are from 106, Lordship. Findings itself show that no involvement as such.
Oh, you have been removed, dismissed.
Yes, Lordship, page 111, last page, 111. But the inquiry report does not state anything of any specific nature, what wrong I have done, Lordship.
Okay. Let us go to the show cause then.
Yes, Lordship. Page 92, Lordship. It was also very vague and general nature, show cause, Lordship. If I may please read the charge 1, Lordship. As per the report of the Deputy Commissioner of Police Crime, when you were posted in the office of the CO Gauhati, Circle Officer Gauhati, you were arrested in connection with Bharlomuk Police Station case number Omuk of the Indian Penal Code. Therefore, you are charged with violation of Section 13 PC Act as amended for committing gross misconduct and failure to maintain absolute integrity. Lordship, PC Act was never there in the Bharlomuk PS case. For the first time, it emerged in the SCN. As 2, when you were posted in the office of the Circle Officer Gauhati, you as a public servant were involved in fraudulent activities and hence you are charged with offense of criminal misconduct. As 3, when you were posted in the office of the Circle Officer Gauhati, you had indulged in alleged misdemeanor, hence you are charged for abuse of your official position. I cannot make out, Lordship, what is my offense? Still, based on the content of the FIR, I have submitted a WS.
Yes, where is the inquiry report?
The inquiry report, page 102, Lordship. Interestingly, Lordship, the SCN contains a list of witness and list of documents. The only witness is the IO. The only document is that letter, page 90.
Okay, let us see.
Yes, page 90A, Lordship. Page 90 is the letter which was sent to the DC by the IO. 16/3/2024. Paragraph 2 will be relevant, Lordship. Next page. Note below. Subsequently.
Now, who had deposed in the inquiry?
In the inquiry, Lordship, the complainant informant who had objected to the mutation, Mr. Dushman Tomedi. It is apparent from the records that I have also stated in my report that there is an objector. I have recommended hearing of all parties concerned.
Only one, that complainant, she was the only witness.
Lordship can find this in the
These
inquiry
documents which are there, who produced these documents?
report. In the inquiry, Lordship.
Huh?
Some documents I had produced. Some
No, see, page 104.
Yes, yes, Lordship.
Now, these documents, who produced before the inquiry? Officer?
Lordship, all these documents were either available from the letter furnished by the DCP to the DC, or by the written statement which I had furnished, or by the informant.
There was a daily order sheet prepared?
Lordship, I have not been given the depositions also. I have only been given the inquiry.
Only one witness deposed.
To my knowledge, I have not been given the opportunity to cross.
Yes, madam. Why these records are not coming? It's in Gauhati only.
It is in Gauhati.
We required these records on 25/2.
Yes, Lordship.
There was no election at that point of time.
Yes. But yesterday when afternoon, I hardly any time to call for the record and.
You get the records. We'll have it on Friday. Or Friday is a holiday, Thursday. Serious matter. Let us see how you did it.
Right,
You have
Lordship.
just gone and seen the documents and passed an order.
There is
That's
the
the-
Lordship, only because I got arrested.
You
I
give
am
me the
entitled.
decisions of the Supreme Court. Get calm
Lordship.
yourself, huh? Huh?
Page 107. Your Lordship.
What?
Point number 789, Lordship, the report that
Who produced that report before the authority, before the inquiry officer? He cannot just go and get that report and pass orders. Somebody will have to prove it. Whether it was done in his presence or not, that's what I want to know. Report is very good. It's very overwhelming report, but the inquiry officer cannot just go and pick up a paper and do what he wants. There is a procedure for that. That much only, Ms. Vachaji, please, madam, you just get that. Heard Mr. D. Saraf, Learned Counsel for the petitioner. Ms. M. Vachaji, Learned Counsel, who was has submitted that that she would make her submission on Thursday. 6/6/2026. Along with the records of the case, which she undertakes to produce on the records of
the disciplinary proceeding.
Records of the disciplinary proceeding. Original records of the disciplinary. Registered to list 6/4 for further hearing.
Obliged, Lordship.
1 o'clock. Where is Miss Musari? Get hold of Miss Musari.
Within 20.
Where do I get this 6? I just 6/2/23. Communication
6/2/23. That is in page 91, and other pages are also there, Lordship. Plenty of times it's been in action. '93, 121, 161. We come to 93, it is there also.
No, 1910/22. 1910/20.
Oh, before that, it is in Lordship, page 46.
Yes, madam. What is the instruction? Wait. Madam, you can take your seat. Who permitted her to go on VRS? No, he did it on the instruction. You will find out that later. You come to page 28. If you had accepted the resignation. Thereafter, you on your own, Director of Secondary Education, 5/5/2009. The order issued by so and so, so and so, so and so. So So if you permit her to go on voluntary retirement, that means you will have to give it some meaning.
Yes, Your Lordship, but whenever that proposal, what the government is, because it does not, or the requirements under give her pension. Wrong, Your Lordship. I do understand it's. See,
Give her the proportionate thing,
Yes,
that's
Your
all.
but what they have, why they have been. Because,
They have not taken into factor page 28.
yes, yes. However, I had a talk. Actual scenario. Your Lord. Again, sending.
Something.
Yes, Your Lordship. That should have.
Because see, if it was resignation, then it would have been forfeiture.
Yes, Your Lord.
Now, she does not admittedly fulfill the requirements for a resignation, for a voluntary retire. But see, you people with open eyes had permitted her. So now, she having moved out on that way, how will you put her into further trouble?
That by Your Lordship.
I can dispose of this matter. There is no problem. I can dispose it by saying that please take a call under 234. She will have to again come back.
Again come back.
That's why I'm insisting that I want this. So that we dismiss it, we allow it, it's at least final. Then the question would be an appeal, not remanding back the matter to you. I don't want to remand back the matter.
That was. Lordship will allow me some.
Well, fine. Miss D. Musahari.
May I, Lordship? In that case, how much time will be taken because
I'll-
it's ongoing process, Lordship.
Madam, you
Because
want a
this,
final consideration?
Yes, this order which Lordship has given the direction, this is the third time, Lordship, with this honorable court.
I know, ma'am, how to get
Yes,
my orders
Lordship.
complied with. I know. You please don't worry. A day petitioner in person. Ms. D. Musahari, Learned Counsel for the petitioner, has submitted that. The respondent authorities, the government in the education department had rejected the proposal of the petitioner by only reckoning the fact that the petitioner had, while proceeding on voluntary retirement, not fulfilled the criteria with regard to the tenure of service as well as the criteria pertaining to age. He submits that the rejection of the petitioner's proposal was for at least a proportionate pension was done on the set count. Ms. Musahari has submitted that what the respondent authority, what the government had not considered was that the petitioner who had submitted her, a petition in person who had submitted her representation, her resignation, was subsequently permitted to withdraw the same and proceed on voluntary retirement. Accordingly, he submits that the petitioner's voluntary proceeding on voluntary retirement with effect from 1/1/2006 was in terms of the decision arrived at in for revocation of her resignation letter and permitting her to proceed on voluntary retirement basis by the Director of Secondary Education, Assam. Also, in view of the above position, Ms. Sahari submits that the Directorate of Secondary Education shall once again take up the matter with the government by highlighting the above position of law, position emanating in the matter, and would seek for a relaxation of the provisions of section rule 234 of the Assam Pension (Services Rules 1969) to enable the petitioner hearing petitioner hearing to at least receive proportionate pension and other proportionate pension and other pensionary proportionately also. The present writ petition is pending since 2023, and prior to that also there were litigations on the issue which was raised before this court. The petitioner in person hearing commutes from Calcutta on every date of listing, and this court cannot ignore this said aspect of the matter. Also, however, considering the bona fide submissions made by Ms. P. Mushahari, but considering the submissions made by Ms. Mushahari, which this court finds is a bona fide one, trying to resolve the issue, for resolving the issue, raising in the present, this court grants one last chance to the respondents in the second in the education department to arrive at a final reconsider the matter and arrive at a final conclusion. Also, the final conclusion and pass an order, final conclusion and apprise this court of the same on the next date of listing. How long will you take? Tell me. I'll give you how much you want, but this is the last. Next time we are disposing of the matter either this way or that. You will not be able to.
In May.
May. I'll give you time till Tuesday. It's a hearing day. We'll hear the matter on that day. Till 12/5/2026.
May I, Lordship, in that case, if it is on 12th of May, there are plenty of events in both the states because election results and everything.
Madam, you give me.
And we have the summer vacation also.
When?
In that case, Lordship, either in the last week of May or on the first week of June.
Last week of May, 26/5/2026. 26/5/2026, huh? Also, in the event the instructions are not produced, this court would proceed to take up the matter for final consideration and also consider imposition of cost for the delay occasioning in for non-furnishing of such for not complying with the directions passed here in above by this court. Registrate to list this matter again on 26/5/20. And Ms. Musari, kindly, I'm just waiting because of the statutory bar that is there. That's why I want you to take a call. Otherwise, we'll devise a way to get this matter through. This lady, the petitioner at least worked 10 years, and it was on you. Otherwise, she would have been happy that I submitted resignation, I don't get anything. Now you kindle that hope in her.
May I, Lordship, only one submission with all humility. The Assam government has already been mentioned. If someone has worked more than 10 years, no matter what, if you have given the resignation, you will get the pension. It is there. And this is the very much opportunity has been given. So whether I have given my resignation or not is immaterial. Yes,
Your resignation is no longer there.
Absolutely, Lordship.
If your resignation was there,
Yes, Lordship.
Madam, I would not have heard you even for a second. I would have dismissed your writ petition.
Yes.
If your resignation was there, because it is settled position, once resigned, the entire past service gets obliterated. But now that you have been asked to go in a manner known to law, we'll see what benefits.
Obliged, Lordship. But only one thing, Lordship. Here, when the sanction, which has been sanctioned without the voluntary retirement, only I'm talking of the sanction with the simplification. There it has been clearly written. If you have given the resignation, if you don't fill up the application, no matter what, the government will pay you the pension.
The government got entangled itself in the matter by its actions. And you're getting your provisional pension?
Very nominal, meager amount.
I'm not
it is also a defect, Lordship.
That is the ma'am, that is the umbilical cord now, which is connecting you to the...
For 20 years, Lordship. It is a
We-
gross
we are
mistake,
there.
Lordship.
We are
Provisional
there. If
pension.
you are entitled, if you find that you are entitled, we'll give you from the date you had proceeded. Within a particular time, they'll have to give you. We find you entitled. Don't worry about it.
It is too long. Obliged, Lordship.
That's it. I'll be back at 2:15. Mr. Monto, any further?
That day I was blushing.
Hmm.
At page 39 to show that what was the stand taken at the earlier stage of this particular issue by the state government. The issue was raised on behalf of the petitioner at that time that the advertisement made, the conditions would have been in accordance with the UGC rules. The government came up through the additional advocate general that time that no, we have a definite line of guidelines. It is in tune, no doubt, with the UGC guidelines, but we have our own set of guidelines and we will proceed according to that guidelines only. The UGC guideline as such, notifications as such, will not be applicable in this case. That was recorded by the judicial order of this honorable court.
This is not in connection with your 2009 UGC PhD regulations.
Yes.
This is in connection with that earlier regulation pertaining 2010 regulation pertaining to.
I'm coming to it also. Coming to it. Now, my lord, therefore, this, what was the, here at page 39, the learned additional advocate general therefore submits that this writ petition may be disposed of. Lordship, got it, my lord? At page 39? Yes. Towards the middle, my lord, the learned advocate general right hand column, his line starts.
Commits
And
that the petition may be so and so with
maybe-
the fresh process.
Yes, press process of selection for the post of principal of the provincial health colleges in Assam by issuing necessary corrigendum in the right of the amendments which have been made in
No
the Assam
objection has been raised by the writ
so and
petition.
so. Yes, and other parameters sanctioned which have respondents have already filed, fixed and finalized. The parameters have been fixed and finalized. Accordingly, it should be made.
Yes.
Yes. Now, my lord, kindly see, their advertisement was issued and what was the guideline? Lordship is right in pointing out that here issue is appointment to the post of principal. Now, what are the requirements? What is the guideline? It says at page 41, my lord. Guidelines, academic qualifications given, assessment, so and so, ability, C, D, E, F. Lordship may skip over required qualification, post of principal, provincial health colleges of Assam, master degree, that is applicable to us. Required qualification towards the bottom. And then serial 2, PhD degree in concerned allied relevant disciplines in the institution concerned with evidence of published work and research guidance. Research guidance, evidence of research guidance. This is the requirement. Now,
There's one thing, Bolin Chetty. He has no IC also. He has been appointed.
this is the minimum requirement. And then new publications made. And when the post was not gone ahead with, process was not gone ahead with, we came before this honorable court again. And this honorable court at page 48, judgment by
The advertisement is page 44.
page 40. Page 40, Lordship has seen it. Once more, Lordship may, I may just.
I've got it, I've seen it.
Yes. So evidence of guideship.
Evidence of.
Evidence of guideship. That is nothing more. And then 48 page judgment dated 39/16. This judgment ultimately goes to, and all having reiterated, we may skip over and straightway come to page
This judgment has 2 writ petitions and 1 review petition.
one review petition, all taking together. Here, para 62, Lordship, may see at page 84. 84 and 89. 84, no? Yes. Lordship will see. It is hereby directed that the governing body of Pragjyotish College, Gauhati shall complete the selection process for the post of regular principal of said college initiated by the advertisement dated 5/12/2011. This is the malad penalty.
Mr. Monto.
Yes.
Mr. Monto. Mr. Monto.
Malad.
Wait 2 minutes because we'll be rising at 3:15.
Yes.
Any urgent matters, because this will take some time. Any urgent matters that requires consideration or any interim order is to be extended. Otherwise, I don't think so it will be possible to take up the other matters today. 34, 33. 8 DD hai milai diba. 34 to more pathad ase, mane padai ani. 233. 8 DD.
Sir,
You can give her dates because today I don't think so it will be possible. I'll have to complete this. And there are other few matters. So whenever it's convenient to you, please have a date taken from her.
My lord, could you have it on Thursday at 2 o'clock?
Thursday would be difficult. Thursday board is na. Thursday would be, it will be next Tuesday or Thursday. Next Tuesday.
Next Tuesday at 2, my lord.
2. 34.
34.
7, 2. So take diddly whole money word.
Lordship, my lord, 7.
A time being I'll take up. A time being I'll take up.
7/4.
My lord, I have a prayer before my lord. Item number 30 to my lord.
Can't take it up today. It will not.
My lord, if possible, my lord.
She'll give you a date.
Vacation date will be given. For vacation, my lord.
Lordship.
Mr. Bode.
Lordship, item number 41, your lordship. Has been, your lordship, this matter relates to your lordship reinstatement, your lordship. In fact, it's a covert case, your lordship.
I've seen it.
If it can be taken up on Thursday, your lordship.
So this Thursday, Mr. You'll be just waiting like this. There are many matters. Have it on Tuesday or Thursday. 41 to next week. Yes, sir. Whole day, whole week or bit khali ase tar video.
Lords.
I'll take it up and finish it. I've prepared that, but I'm sorry today.
Lordship.
Yes, Mr. Count.
Item 30 and the interim has to be extended.
Just tell her. She will do the needful. So you need not wait. That's why. Mr. Soikia, what are you waiting for? What are you waiting for?
Same matter.
Same matter.
Same.
Two seniors.
He is comfortably taking the back seat.
That's it. He is the master of the ceremony. Yes. No, I feel bad. People waiting, matter not taken. That's why.
It is better because time is running out. They will not get any opportunity. So I was placing at page 84.
60, para 62.
62. So it is hereby directed that the governing body of Pragjyotish College, Gauhati shall complete the selection process for the post of regular principal of said college, initiated by the advertisement dated 5/12/2011. This is the date, my lord. On or before 30/11/2016, following the provisions of the Assam College Employees Provincialization Act 2005, Assam College Employees Provincialization Rules 2010, and other government rules and procedure and the UGC norms, circulars and guidelines for the said purpose as applicable on 5/12/2011 as applicable. That your lordship will mark on 5/12/2011. And further, the governing body of said Pragjyotish College by 5/12/2016 shall recommend the selected candidate selected by the selection committee duly constituted by the governing body of the college to the Director of Higher Education Assam, who in turn shall issue the necessary order of appointment to the concerned selected and recommended
The other
candidates.
things may not be very vital, but this is vital.
Yes,
All rules and UGC norms, circulars as applicable on 5/12/2016.
As applicable on that, and that
And you
the
would
other
argue that,
direction is also very categorical. They
you would
didn't-
argue that by this time the court had passed the order, the clarificatory OMs were already on record.
Already there. Already there. And Lordship will see, my lord, the very positive direction given by that court at page 85. They never challenge it. It says that once the candidates is recommended by the selection committee and the college, so director is to issue appointment letter. That was very categorical and positive direction. The director of the higher education, who in turn shall issue the necessary order of appointment. It leaves no scope for them to go on further scrutiny because they didn't go against this order. They didn't challenge it. It has taken the finally. That is my case.
Got it.
They could not have deviated from this direction. Now, kindly see how the things proceeded again. When this was recommended, what was the plea they have taken? They have taken the plea.
This is that Assam Institute of Advanced Studies.
Exactly. This is to, what is it related to? This impugned order,
127.
page 127. Yes. 127.
1/7.
Let us see this, my lord. Peruse the order dated 26/3/2018 passed by the Honorable Gauhati High Court in WPC so and so. This and also the order dated 30/9/2016 passed by the Honorable Gauhati High Court in WPC so and so and other connected cases. And also seen the proposal governing body resolution of the Pragjyotish College Vide letter so and so dated 22/11/2016. Well, that page 127.
I've got it. I've got it.
Yes.
Yes.
2011-2016 from the president of the governing body. I have also gone through the records of interview held on 22/11/2016 pursuant to an advertisement dated 5/12/2011 for the post of principal of Pragjyotish College. In the resolution of the governing body dated 22/11/2016, whereby on the selection committee, the governing body of the college recommended approves the name of Dr. Ranjan Kumar Bora for the post of principal of Pragjyotish College. As upon checking verification of the records at the directorate, it is found that in support of evidence of research guide, the selected candidate submitted the following documents. A certificate dated 4/2/2011 from Assam Institute of Science Studies to the Advanced Studies to the effect Dr. Ranjan Kumar Bora, Senior Grade Lecturer, Department of Botany, Pragjyotish College, Gauhati, is an approved guide of the institute, which is an authorized study center of Vinayaka Mission University, Salem, Tamil Nadu.
That would be of no consequence because that is not a university. So we forget.
Gone.
Two will be relevant.
Yes, done, gone. Two will. Guide approval letter, Vide number so and so, dated 1/7/2011, from CMJ University to the effect that Dr. Ranjan Kumar Bora, Department of Botany of Pragjyotish College, Bhorulumukh, Gauhati, 9, Assam, is approved as a research guide for botany. A certificate from one Dr. C.M. Sharma, former professor, head botany, Gauhati University.
That is also not.
Yeah, this is also not relevant to us. Now, 128.
Last paragraph.
Yes. Now, the moot question for determination is as to whether the certificate is supported in support of research guidance issued by the CMJ University is to be accepted or cannot be accepted on 5/12/11. For the provision of the Assam, further the provision that college has missed probably. Further, the provision of the Assam College Employees Rules 2011 as per Rule 7C of the 2010 rules for the post for which UGC has prescribed norms. No candidate shall be recruited without having the required norms. As per the UGC minimum qualification for appointment of teachers and other academic staff in university and colleges and other measures of standard of higher education, Regulations 2010. The mandatory qualification required for post of principal of a college is 4.201, a PhD degree in connected allied relevant disciplines in the institution concerned with evidence of published work and research guidance. That is it. There are also only evidence of published work and research guidance. The UGC minimum standards procedure for award of MPhil PhD degree Regulation 2009 deals with the condition of conducting the MPhil and PhD program. As per Regulation 5, no university institution deemed to be university and college institute of national importance shall conduct MPhil PhD programs through distance education mode. As per Regulation 6, all university institutions deemed to be university and college institutions of national importance shall lay down the criteria for the faculty to be recognized as a research supervisor for MPhil and PhD programs. Further, Regulation 7, all university institutions deemed to be university and colleges institutions of national importance shall lay down and decide on annual basis a predetermined and manageable number of MPhil cum doctoral students dependent on the number of available eligibility faculty supervisors. As per Regulation 12, the allocation of the supervisor for a selected student shall be decided by the department in a formal manner depending on the number of students per faculty member, the available specialization among the faculty supervisors. UGC guidelines issued VDA number so-and-so dated 6/7/2015 say that universities shall allocate the supervisor from amongst the regular faculty members in a department or its allied.
Mr. Nota, you need not take the trouble, we have got it.
Yes.
He only says that you are not been, he first discusses that it should be within a department.
Yes.
And then he goes on to discuss about 6/7/2015.
Yes.
And that you are not affiliated college, Pragjyotish is not an affiliated college with that.
Yes.
So he says that that cannot be taken as a
Yes.
research guidance under UGC 2009. End of the matter.
Yes.
Huh.
Well, before this order was issued, the authority had the occasion to consider this very aspect earlier also, wherein they took the plea that this cannot be approved, this guide certificate cannot be
Because there is
approved.
number of litigations
There are
pending.
litigations pending. That Lordship will see at page which was put to challenge again, and thereupon Honorable Justice Molla Buzar Burua passed an order. That is the order what is it? Just finish.
5/1/2017. That is at page 86.
I am grateful, my lord. Yes. Annexure 5, page 86. It says, well, kindly see. Yeah, it says the Assam Institute, last para, but one. Huh? It is the order.
5/1/2017 is at page 86, annexure 5 to the writ petition.
Yes. This says, so first, the Assam Institute of Advanced Studies is not a university and is a study center of the Vinayaka Mission University, Salem and Tamil Nadu, so and so. Hence, the certificate in support of such guidance cannot be accepted. This office cannot accept the certificate given by the CMJ University also, as there has been much litigation over the university in recent past, although its name appears as a private university in the UGC consolidated list. As such, the recommendation of the governing body is rejected.
Mr. Monto, you may also take this quote through the order, last order of my Lord Justice Borua, 26/3/2018.
Yes.
Because there is a argument
Yes.
at para 6, para 5 onwards.
Yes. Yes, at 125, my lord.
125.
I'll place it. Lordship has seen that order. There they only mention that because litigations are there. That was the ground. What I want to indicate is the authority had the occasion to consider this certificate in respect issued by the CMJ.
Earlier also.
Earlier also. So what was there in their mind?
No, the problem here is that order was put to challenge.
Yes.
And if you come to 5, therein, the counsel appearing for the state had referred to the clarificatory office memorandums.
Yes.
In para 5, 6. But the court in para 7
yes.
noticed
Yes.
that these were not the reasons for passing the order.
Exactly.
And then at para 8,
yes,
it rejected that.
Rejected.
Now, while setting aside the order,
Yes.
as regards the reasoning given, in respect of so-and-so, while not interfering with the other reason, the matter is remanded back to the director for a fresh adjudication as per law. And in doing so, the earlier orders dated 30/9/2016
Yes.
passed by this court may also be taken into consideration.
Yes.
Now, 39
Yes.
had restricted the consideration as of 5/12.
Yes.
So that was again reopened.
Yes. 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 We're going to reopen.
So it is only without that clarifications we come to a conclusion that the 2009 of the regulations, PROCEEDINGS regulations, were in a particular direction. Then only it will be permissible for us to support that. Otherwise, if there was an ambiguity there, it was understood in a different manner and applied, then we'll have to come with you.
We'll have to
come with you.
Yes.
Correct.
So, well, here that 39/2016, that order has been referred to. At page 85, this appears. We have already read it. That is the
85.
judgment of Honorable Justice
My Lord Justice Pathak.
Justice Pathak, which says that as on that date you consider, and if applicable, other things you will have to see to it. Now, that itself, that is having taken into account, they passed the order saying that no litigations, no. It was put to challenge. Again, court said, what I understand, by my humble understanding from the direction of this court here, it leaves no such scope to go through and dig out some new ground.
It can only be in terms of the thing which is there in, as on 5/12/2011.
2011.
Now, if you read the impugned order, Mr. Das, please take note of these points. If you read the impugned order, it also refers to materials which had come on record after.
After. How can? This is a serious issue, my lord, to be looked into. Impugned order at page.
Page 127.
Yes, 127. We have read it. The authority has gone into searching for new documents, taking into consideration those documents, relying on it.
Is there a bar in the act with regard to age for appointment?
Yes,
Mr.
they have,
Das,
they
there is
have a
bar
guideline of their own.
Age.
They have their own. Their requirement is there mentioned. Education manual to anna guideline. One basic thing, my lord. This particular certificate was issued. There is no denying of the fact that I am a research guide as per the certificate issued by the university. That was never put to challenge. This was never the issue whether I could have at all been appointed as a guide. It was never an issue whether the persons who have obtained the doctoral degree under me is a legally sustainable degree, legal degree they have obtained or not.
Have you guided people?
Sorry? Yes.
Have you guided
Yes.
people
Yes.
in CMG University?
Yes. They got doctoral degree. So therefore, it was never an issue raised by anybody in the university did not cancel that or withdraw that certificate. Even the authority appointed persons who had no guideship certificate. It is there I have placed on record.
Yeah.
Yes. And therefore, the evidence of guideship, very limited to my humble understanding, my lord, whether there is any evidence of guideship. Can the authority now challenge that this is not an evidence of guideship? They have to get the evidence of guideship for their support. And this guideship certificate is a valid one prevailing on that day. It is prevailing even today. There was no challenge to it. That time the authority never issued any order directing that no, you could not have been a guide there. Therefore, your guideship certificate is not workable. We are not recognizing it. So you cannot act as a guide.
Those people might have got employment basing on your guide.
Exactly.
Okay, got it. Anything more?
Therefore, my respectful submission is the ground now ours is absolutely baseless. They cannot. They are only to see whether there is evidence of guideship or not. Simple. And the certificate is an evidence of guideship. They cannot now go into a roving inquiry, making all things taken together and coming to a conclusion. No, this is not the issue now before them. They could not have done it. My respectful submission is this. Therefore, on that limited issue itself, my respectful submission is when I am submitting earlier also, my lord, even 2010 UGC regulation speaks of the qualifications required for becoming a principal. There also, what is the requirement? That evidence of guideship. And they have also taken this as per their guideline also.
Mr.
state
Monto,
guideline.
when you take that two words, evidence of guideship, you also have to take a word preceding that. That is published work.
Published.
So published work you have to give.
Yes, this was
the-
there.
the-
They have
the-
denied it. Oh, that published work is already there. They are not coming to it. This is not the question raised by them.
Okay. Where is Mr. Gogoi? So, Mr. Monto, if I have understood you correctly, just your basic submissions, you give me a written argument. Just the way Mr. Monto has argued. First, advertisement issue. We'll not go before that. We are
Yes.
sticking to 5/12,
Yes.
2011 onwards.
Yes,
Advertisement issued. Selection done. Your name recommended.
yes.
It goes before the authority. The authority finds fault with that on two counts. One, that you don't have a
Valid.
valid guideship certificate. That guideship evidence that you produced was from IAC. That admittedly was not right. That is a fine. That's a correct conclusion. Second was from CMJ. CMJ not permissible because there is a lot of
Litigation.
litigation there.
So they never nullified it that time on that ground, any legal ground.
Then you again come up before this.
Yes.
Now, all these things are being guided by an order passed by this court, page 84, para 62, 39, 2016.
Exactly.
Which had put a bar that everything will be as of 5/11/2011. 5/12/2011.
Yes.
That is not gone into much by the court, but the court finds that now that, because in the affidavit filed to support the 5/1/2017 order, they had brought on record the subsequent notifications of the government,
Yes.
of the UGC.
UGC.
But this court rejected that in para 7 of that judgment,
Yes.
saying that Mohinder Singh Gill, this
Yes,
will not
mind of
come
it.
in.
That is, I am relying.
This will not come in.
This will not come here.
So it says, now again, go back and do the exercise, but in terms of page 84.
85, confined
85,
to-
para 62.
Yes.
Does not, it says only the judgments.
Yes.
Now it goes back to them.
Yes.
It goes back to them, and that order passed by my Lord Justice Pathak, having been advanced, reiterated by my Lord Justice Barua, the respondent authorities could not have moved thereof.
Exactly.
It should have confined itself there. Even if that 15 notification is a clarificatory notification,
Yes.
that cannot be taken into account because that was not there on 5/12/2012. The cutoff limit is 5/12.
Exactly.
Don't go beyond that.
Go beyond that.
So, this order on the face of it, having considered those issues, 2 minutes we can set aside this.
Yes.
No issue. But I would not like to do that. I would like to go further, determine the issue finally. Because again, going back, tomorrow they'll again pass an order, CMJ, this,
Exactly.
that, come back. So we decided here, but this is your basic conclusion. We decided here whether only from the point of view of 2009 regulations, you had a guideship or you did not have a guideship. If you had, you get it. If you don't have, you don't get it. Basically, this is the approach I would like to take.
I see. Fine. My lord, in that case, as I have submitted, kindly see, that time.
Because we are now down the lane around 14, 15 years.
Yes. Exactly. Yes. For 11 years gone. And they are taking one after another ground just to deny me. Whereas, as I have placed, persons who didn't have any guideship also that time, they all
That's
had
why I
to-
said, Mr. Monto, as on 5/12/2011, the norm was this: if we find that there was an ambiguity in 2009,
Yes.
which was being interpreted in particular manners by the,
Yes, yes,
then that interpretation as of 5/12/2011 has to be applied in your case.
yes.
I'll try to, my approach would be to examine that issue.
My lord, here, Lordship has seen this 2009 regulation for award of MPhil PhD degree at page 101. What it says, all university institutions deemed to be universities and colleges, institutions of national importance shall lay down the criteria for the faculty to be recognized as research. It was left to them. It was left to them who should be recognized. Lordship has seen this. This
It's
area is a
only used
gray
the
area.
word faculty.
Gray area was left.
So there can be two ways to look at it.
Exactly.
We'll have to determine which is the way to look.
Way to look.
One, faculty means faculty in general.
In general.
And two, faculty means faculty within the university.
Within the university, institution
And that
itself.
cannot go even outside the university to its affiliated college.
Exactly.
It has to be, say, if it is botany, it has to be professors working in the botany department.
Exactly.
Or associate professors working in the botany.
Botany itself.
It cannot go, say, Gauhati University. Gauhati University will confine it within Gauhati University Botany Department. It cannot come to Viborua College Botany Department to pick up somebody.
Exactly.
So that's the areas where I have to apply.
So, that time, there was some ambiguity. This was not clarified. This was not clarified. It was not understood in that strict
It was
technical
rather
sense.
understood in the other way.
Other way. So many appointments or so many guides were appointed, and ultimately the authority realized that there is a need for clarification.
That clarification came after 5/12.
6 years. Thereafter
Yes.
the clarification came.
Okay.
The other day, my lord, the State Council submitted certain the judgments. I have gone through this. All this relates to the direct issue of the certificate, whether guideship was rightly allotted or not in those cases. In those cases.
It is in Quadi PhD student.
Exactly. What the PhD students. That was the issue there. This has no direct bearing in this case. Those cases have no direct bearing of different high courts they have relied on. And 2010 UGC guidelines, they have admitted this is not admissible. We have not adopted it. This honorable court has decided it.
Mr. Monto, with that argument with regard to Qua 2010 regulation, I'm with you. Because that is the stand of the government.
Yes.
All along, that it is to the extent of adoption. But 2009, I think I'll have to go with Mr. Gogoi on that, that it will not mandate an adoption or non-adoption. It is automatically applied because it relates to award of
Qualification,
PhD.
eligibility of those guides.
Because the 2009,
yes,
the para that you showed me,
yes,
that is Qua 2010 regulation.
Yes.
No problem. They have been taking that argument. Supreme Court also, in some cases, have said it is mandatory. Somewhere it has said directory. This court also, many orders are there. It's directory. I have appeared in one or two matters wherein it was said it is it is mandatory.
Yes.
But it's a dicey field. But all said and done, 2009 cannot be brought within that fold. 2009 is mandatory.
Now, therefore, even if we take it, I go by your lordship's view that this is mandatory. For what? For
Only for award of PhD.
PhD, MPhil. That's
the ambiguities that are there.
Yes.
Will have to be
applied
and addressed by this court.
Yes.
How? That's a different thing.
Yes. Now, therefore,
but we proceed with the matter that 2009 is a mandatory, is applicable, although the government may take a stand with regard to UGC norm regulations, that until and unless we don't adopt it, it will not be applicable.
Yes.
2009, that plea will not be available.
If that is to be understood like this, that this normally applies because it relates to the qualification of the PhD. And
supervisor is one of the things in that line.
Yes, in that line. That is why my submission was.
I got it, Mr.
That is why my submission was that those process was completed, done, everything done, no issue.
The interaction I have in such matters, is so that I can get all the materials here. And I dictate, I just on it. And I think, what did sir say? Oh, this one. So that's why I don't mind. I keep on interacting. It gets recorded there. And it's very useful for me when I dictate finally.
Now,
I got it, Mr. Monto.
yes, therefore,
You give it to me.
therefore,
The way Mr. Monto has argued. Don't bring in unnecessary things. Only this much.
therefore, my lord, that certificate, validity of that certificate, not validity, as a evidence of guideship. Its validity, its eligibility or otherwise, illegality or legality otherwise was not an issue here. They could not have done it
You
because
project that it is only whether that candidate had acted as a supervisor, where he acted, how he acted.
No,
it's not for you.
Not you cannot look into it. You cannot look into it. Your limited scope is
Then
there.
Mr. Monto, one more clarification.
Yes.
Because that line again contains this published works.
Published works.
So you publish a work.
Yes.
Say in a college, your college, say you have a
published,
what do you call that, monthly, yearly, we take
Yes,
a souvenir.
Yes, souvenir. Huh.
So will that work?
No.
How do you place that there?
Those public works must be of certain standard so that certain journals.
Standard, say it is a very good article.
Yes.
It's a research article, but he published it in the souvenir.
Not souvenir will not do.
So that's what I'm trying to understand. How do you ascribe a meaning to that evidence or published work?
Published work, they will find out from, well, the name is not coming to my mind right now. Certain journals.
UGC care list is there.
UGC, there are certain journals which are so approved by the UGC, and there
it does not say that it has to be within that journal.
No.
That words used.
No.
It's
Only
not there.
published work.
Only published.
Only published.
Envisaged published work.
Yes.
Say I have published that in a form of a novel.
Then also.
No, whether that will be also applicable. How do I understand that?
Going by the requirement in the advertisement, that is sufficient for them. They have not clarified that where it must be published.
That's what I'm asking you.
We will take only
But what is the normal standard?
Normal standard, to my understanding, as I knew, although there are certain journals so prescribed or authorized. There it must come up.
So, Mr. Monto, if you ascribe that meaning to that term, evidence of published work, why that same principle will not apply for evidence of guideship?
Yes.
Because if guideship is not a general that any university can come and give you, but it has to be given to you by your own university, by your own department.
Yes.
These two, would you take it together?
Now, my lord, here, my first question, answer to your lordship's query would be, had there been some ambiguity relating to the published work, they would have taken that ground.
You have not on that.
They have not taken.
I'm not on
that.
I'm not on that, Mr.
Yes.
My query, my doubt is,
Yes.
you say evidence of guideship. It has to be understood that you have a guideship somewhere, and that's enough. Now that same line also has a word, evidence of published work.
Evidence of published work, that is why my submission would be, since they have accepted it, the published work may be published in any other journal, may not be a prescribed one.
That's what I'm asking.
May not be a prescribed one.
Because normally they have not raised that question.
Yes.
But be that as we have many cases to that line.
Yes.
So UGC care list is earlier that point of time,
Yes.
UGC care list was there.
Yes.
Subsequently, it was given up. Or Scopus or something, wherever you publish. Now, there is a definite meaning. Everybody understands. Like you have a meaning in a particular term in a trade.
Yes.
Say oil.
Yes.
Or essence.
Yes.
We have that meanings, and there are saying this, if I say oil, scented oil, I will mean this. And oil, MOL, motor oil, I'll mean motor oil spirit, I'll mean the petrol, diesel, and all those things. Now, that is known. So, teachers who are aspiring for a post of principal, they know that, see, this journal, I'll have to publish my works in X journal or Y journal or Z journal. I cannot publish it in my school souvenir, college souvenir, and get it, although it might be a very highly researched.
Yes, yes.
Similarly, guideship. It has to be understood that a guideship, if we read 5, 6, 7, and 12 together, just ignore guideship for a moment. Just ignore that. How a supervisor is allotted to a PhD scholar,
Yes.
if we read it, it is done by the department from its faculty.
No,
Now, how do you synchronize
yes,
these two?
my lord, because of the ambiguity in the 2009 these provisions, it left the area open for the university to their understanding.
You mean to say that is why they clarify?
Yes.
Okay, done.
Therefore, they have appointed so many people.
Done. Understood.
And so for the other aspects, published works, they might find that this may have been published in the X journal, Y journal, or we are happy. No issue.
Got it.
Therefore, this cannot be, they cannot now say.
Got it.
There is no such discrepancy.
Okay. Yes, Mr. Das. He was supposed to give me a note also. Mr. You want to make some submission?
Guidelines are 5, 6, and 12. 5 is very clear. 5 is very clear. Is that not?
Mr. Nath, the argument of Mr. Ponto is not a general that you have a 2009 thing, ambiguity. This is specific. Basing on page 84 order, para 62, this court had said you do anything but do it, but take it, cutoff date is 5/12/2011. So anything we do today, we will have to do as if we are examining the matter of from as of on 5/12/2000. If that word was not there, we could have taken into note the subsequent developments also. But now this court having said that, and that having been reiterated in the subsequent judgment, we will have to concentrate only on 2009 as it stood.
Yes.
That's what I'm saying. No, clarification came after 12. Now, why should we take, because as of 12, that clarification had not even been bought.
Clarification.
I'm not on that. The clarification came in 15, whereas my job in terms of the decisions of this court is to decide it on 5/11/2011, 5/12/2011.
Advertisement, that was.
Be that as it may. That's a date. But anything coming after that, how can I take into?
In fact, the clarification.
No, I can't see it because as of 2012, that clarification is not there. Although it may have an effect. It is being retrospective, clarification being a clarificatory OM, it being retrospective, it may have an effect. But should I look into it?
That particular thing is inherent in ethics.
That's what I'm
IBC
saying. We have to examine this matter because any clarification solely interpreting 2009 thing. Now you see. In the impugned order,
And the
page 127, you come down.
authority, they have taken, I did the math.
How can they take into consideration a particular fact, which this court had already said you cannot? You come to 129, second paragraph.
Yes. Is one. Year 2018. All these things.
Show me a decision. Show me a decision to that.
Argument of
Because we are not going to remand this matter on this point. I'm going to decide it either way. Then what happens? We are not going to give it another 10 years time to this. No, never. If Mr. Montos Klein is entitled, he gets it. If he's not entitled, that's the closed matter. Forget it.
in fact,
But what I'm trying to, why I'm pointing this out to you is that the director also, to support his reasonings, he had to refer to a document which was not there as of 5/12/2000. No, Mr. A clarification may have been, but this clarification came after. How can you go? You come to page 82, very specific. Very specific. No.
ultimately,
You just come to page 82.
I have seen, case 16, 62, I have seen.
No, it's not only 2009. It is not written in the context of 2009. If you just read that.
Yes,
1, 2, 3, 4 lines from below.
yes,
Above, or below.
yes,
And the UGC norms,
Lordship.
circulars, and guidelines
Yes.
for the set purpose as applicable on 5/12/2011. And further, so and so, so and so. Now, this court, while doing this, was deciding this issue. The judgment dated, judgment is dated 39/2016. Now, on 39/2016, at least the first clarification of the UGC was already on record. But this court did not refer to that. Said that you decide it as of 5/12/2000, and it uses the word circular. We cannot ignore these things. And this has attained finality.
Fine. Because this is clarification. Right? I think effect 2009. When it is before. That has fed into that. Because 2015. Add or change thing, make. But in fact, page 101, you kindly see what the language one, serial number 5 is, notwithstanding anything contained in this decision for the time being in force, no university and college of national conduct MPhil and PhD program distance education mode. So distance education restricted in that only. So this clarification says that PMG, so he is a teacher, to go.
No. That argument may not wholly fail. You mean to say how he'll teach in distance education? No, that is not the thing.
That was never.
No, he having guideship of CMZ is not the. He right.
You mean to say that he'll guide through distance education mode?
Absolutely.
This, Mr. Nath, is with regard to the university offering a PhD program through distance education mode, not the other way around.
Is going. Petitioner is a. How he can. University and kindly see 6. All universities, institutes.
You stick to 12.
I'll come. Kindly see 6. All university institutions
lay down the criteria for the faculty to supervise both for and PhD program. Matlab, it has to be done by the university. They got it, frame the guidelines for their faculty. DMJ will do their faculty. Petitioner university and their how it has to be in the 5 and 6 there. Then kindly see 12 color.
Okay. Mr. Nath, if I've understood you correctly, you mean to say that the word here used is faculty, and this faculty must be the person under control of the university at the point of time.
Affiliating in
And para 12 also,
yes.
regulation 12 also.
In a number of our faculty
Member.
The-
Now, what this member? This member means a member of the service of that university. That's what you want to project. Got it.
Here. So, Malab,
That I'll not accept, but I'll accept the, I'll appreciate the other two. First one, I'm not accepting. I'm rejecting straight away.
kindly,
Distance mode, I'm rejecting straight away, but the
that
other
was
two
never
will have
taken
to be given something.
I have
Mr. Gogoi also has made, had referred to this. Okay, we will hear you. Don't worry. Date diya hai. Bond or agot diya. 7-4. 7-4, 2 p.m. Hopefully that day we don't have to reach. This case comes, I have to rise. Kiba out thaki gol na, you know. 17, item number 17.
Right.
Yes. Madam,
My lord.
that earlier selection gone. We are not going to go into that because there is no material brought on record to show your merit position. So the earlier selection that was there, we will reject your prayer to that effect. But why future selection processes are not being taken up? We will direct them to initiate a process of selection for your recruitment, for recruitment of promotion of Anganwadi workers against 25% post of supervisor within a time frame. We can do that, madam.
My lord, in that case, my lord, I have to again sit for exams and all, my lord. And they will be having the liberty to reject me again, my lord.
What exemption?
My lord, exam, my lord. Written exam and all.
Exam, there is a new regulation that has come. You do one thing. You give a copy to madam. We'll take it up on day after tomorrow. Part heard? Heard in part? 2-4. Madam, just make a mention in the morning. I'll fix a time for this. Just coordinate with Mr. Nath also. We'll take it up and dispose. But madam, with the regard to your...
Can it be tomorrow, my lord?
Tomorrow it will be a little bit tied up. Madam, with regard to your challenge to the earlier selection process, I'm making my mind clear. We are not entertaining that. Because there is nothing.
But
No
there is
material.
no illegality, my lord, happen in that case, my lord.
But you have not projected, you have not brought on, you have only brought certain SC candidates who were there.
Yes, my lord.
Whereas your allegation is for the total general
Yes,
selection process. For these candidates, you have not even brought on record the marks. You have not even brought on what are the exact nature of illegalities. You have just annexed, arrayed a few respondents. Kindly clarify.
Otherwise also I am, my lord, eligible for promotion, at least for so many
Promotion
years.
25% through a process of selection. The guideline said oral, but you took part in a written and an oral.
That is my compulsion, my lord.
Now once you have done it and around 234, 235 people have joined, we cannot for you now undo the whole thing because that 234 also will go. So you will have to make them parties here. This will not end in.
I know.
Now that is gone. Fresh one, whether a written examination is to be held or not, that we'll have to see. Ms. Sharma had placed on a record of notification, communication. They say that there is a latest guideline issue. She was supposed to place that guideline. You can give a copy of that guideline to madam also. so that she can also make her submissions. Next day, I'll give us 19.
19.
Or that dresser. Now we have got a document wherein which says that he had uploaded a certificate. Mr. Bora has placed.
But in
It
the
will
RTA
be
reply, they said they're.
Monday.
Monday.
Perfect, huh? We'll see on Monday.
Monday, there will be problem. I'll be out of.
Tuesday? Wednesday?
My lord, I'm going on 4th this month. So, and after.
Second.
Yes.
Second. Thursday. By slip को area. By slip Thursday. और की बात है?